Good afternoon and welcome to the Appellate Division. Before I call the calendar, I have a few announcements to make. The first is that we are actually a panel of 5 judges today. Justice Peter Moulton is participating in this panel. He is watching the arguments as they are streamed to him, and he has provided us with a list of questions for areas of inquiry during oral argument, and I want you to know that. The second thing is, and I know I say this every time I start to call a calendar, that we have a lot of oral argument, a lot of time that's been requested, and so I'm going to call the calendar, and when I ask you today to tell me what you need for oral argument, I'm going to ask you to please be mindful of the fact that we do have a very full calendar with multi-party cases today, so please only ask for what you actually need so that we can get through the calendar in a timely and efficient way. Okay. I'm going to call the cases, and please indicate the time that you need, and I'll assign appropriate time to you. The first case is People versus Milton Headley. Six and six? Oh, okay. All right, thank you. Okay, I'll give you 6, 2, and 5. Thank you. Okay. Mizrahi against Consolidated Edison, and I believe we have 2 respondents on that. Okay, well, so it's 5 and 2 for the appellant, 3 for Con Ed, and 2 for Triumph. Thank you. Napoli versus James. All right, 4, 1, and 4. Thank you. People versus Noel Brown.
Good afternoon. Defendant appellant request 6 and 2, Your Honor. Respondent request 6, please.
6, 2, and 6. Thank you. Rooney versus DP Consulting Corp. We have another appellant. We have 2 respondents. Do we have the other respondent? Only one? Okay. All right, so I'll give you 5 and 2, 5 and 2 for each appellant, and 3 for the respondent. People versus Sean Washington. Submitted. Padilla versus Turo College. We have 2 appellants on that.
Appellant requesting 6 and 2, Your Honor.
Your appellant Padilla?
Yes.
Respondents?
Respondent, defendant, Toro College, 7 minutes, Judge, please.
And do we have all pro?
Respondent, all pro, 3 minutes.
All right, for each appellant, you get 5 and 2. For Turo College, you get 5, and all pro 3. Mara versus Long Island Airline.
For the respondents, 5 minutes.
All right, 5, 2, and 5. CC Realty Service versus Escavallo. Do we have an appellant on that? No? Do you wish to argue, sir?
3 minutes, Your Honor.
All right, I'll give you 3 minutes. Style versus Sierra Custom House. All right, 5 and 2 for the appellant, 5 for the respondent. Okay, Seymour versus Hovnanian. I know we have a lot of parties here, so we have 3 appellants here. So let's start out with Hovnanian.
Given the size of the, sorry, I'm sorry, Your Honor. Daniel Cutler from Western Complex and Wire for I would ask for 10 and 2, if Your Honor is able to give me.
I'm not going to give it to you, but I know your request. Okay, let's move on. We have 3 appellants. Go ahead. Next appellant, what are you asking for? 10 and 2, that's what you're asking for. Okay, signature? Do you want any rebuttal? You're an appellant too. Okay, you're withdrawing the appeal. Okay. So you're just a respondent and you're requesting 3? Okay, Watan? Right. Gilzance Murray? JG Construction? Mitchell Iron? Pelori? And O'Neill? And I think I got you all? All right, so here's how we're going to divide up the time. Hovnanian, you get 5 and 2. Seymour's, you get 5 and 2. All of the other respondents get 2 minutes apiece. English versus Avon Products. Do we have a respondent? All right, 5, 2, and 5. Thank you. Griffon Loring versus Amethyst. That's a submit. Lu Wong versus City of New York, and that's a submit. Okay, thank you. First case up is People versus Milton Headley. You can proceed, Counselor. Thank you.
May it please the court, Alyssa Barnardiani from Orrick, Harrington, and Sutcliffe in association with the Office of the Appellate Defender for Mr. Headley. I'd like to begin with the attempt conviction. Prosecution's case mirrors the facts of Rizzo. A group of men, some of whom were armed, set out in a car to commit a robbery, but they were arrested by the police before they reached the would-be victim. Right. And the Court of Appeals held in Rizzo that these facts were insufficient to support an attempted robbery conviction under the dangerous proximity test, holding that the line for attempted robbery is crossed when you reach the presence of the victim, when the victim comes into sight. That holding applies squarely to the facts here and requires reversal of Mr. Headley's conviction. The prosecution's only response is to claim that Mr. Headley is raising a factual impossibility defense. That's just not accurate. Mr. Headley's argument has nothing to do with the fact that this was a sting operation. Even if there really were drug dealers in Riverdale for the defendants to rob, the conviction would fail for precisely the reasons stated in Rizzo, namely that no one, much less Mr. Headley, got anywhere near those drug dealers in Riverdale. They were arrested more than 100 blocks away. Turning to the conspiracy charge, the prosecution submitted insufficient evidence that Mr. Headley was a participant.
Well, counsel, in addressing the conspiracy charge, there were crucial stages where Mr. Headley was present at, for what would be a conspiracy, right? Particularly when the note was passed in the car and the scheme explained. What did he do after that?
So, Your Honor, with respect to this trap note evidence, the informant came to the car and to the driver's seat and said, this is the trap for the car. So, we submit that somebody who is not involved in a robbery conspiracy to rob drug dealers is not going to know what that phrase means. And so the expectation for, the kind of negative reaction just is circular. It doesn't make sense. But regardless, the defendants, the cars were all arrested about 2 or 3 blocks down the road. So even if you expect some sort of reaction or questions to be prompted by that statement, there just wasn't enough time for that kind of response or that kind of exchange to happen. But more importantly, it is black letter law that presence at the scene of a crime is insufficient to convict someone as a participant in that crime. And that is true even if you know that a crime is being committed, even if you are knowingly witnessing a crime, there must be proof of participation. And for example, in Burke, which we cite in our opening brief, the fact that the defendant was present in a car while a burglary was being committed inside the building that the car was parked outside of was insufficient to convict because there was no evidence that the defendant was a participant in the conspiracy as opposed to, simply a witness. And what the cases that even the respondent cites show is that you need individualized, specific evidence that permits an inference of participation. And the bar for that evidence is quite high. And
Let me ask you another question because the people do raise it. The CI who was speaking to Pollard, and Pollard's representation that he had people come in and that the people in the car, those are the people who are going to commit this crime with me. Should we give that any weight?
So, Your Honor, those statements, the statements between Pollard and the informant before November 17th show the existence of a conspiracy, but the question here is whether Mr. Headley was in fact a participant in that conspiracy, and so they're just not relevant to assessing Mr. Headley's liability in particular. In fact, a lot of the statements that Pollard makes tend to undercut the prosecution's argument. So, for example, Pollard is ready to go. In mid-October, he says he's got all of his crew members together. He is ready. He's pestering the informant. When are the drugs going to be here? He says he's keeping his crew informed. And during this entire period, there's no evidence whatsoever implicating or even referencing Mr. Headley. No phone calls, no text messages, no communication of any kind with any of the alleged co-conspirators. Not even when the robbery is postponed at the very last minute on November 16th. There's just nothing. And so to backfill this evidentiary gap, the prosecution largely focuses on his presence, which is insufficient for the reasons we state in our brief. And they also focus on a series of conversations that occurred in the parking lot between Pollard and the informant. But these conversations are all happening when the informant is pestering Mr. Pollard, where's the crew, why aren't they here? And Pollard's statements in response are demonstrable falsehoods. He was repeatedly lying. Oh, the other cars, they're right up the street. They're parked on Amsterdam Avenue. They're waiting over there. That's all false. We know from license plate reader technology that the other cars were still in Queens at the time. So nothing that Pollard says to the informant in that particular exchange in the parking lot is reliable. He's lying to save face about why the crew.
But even if it's not reliable, though, let me take back the reliability issue. But Mr. Headley was present while Mr. Pollard was making those statements.
So no, Mr. Headley was not.
Well, that car was there. He was in the car containing Mr. Pollard. So the fact that the other 2 cars hadn't yet arrived is not necessarily indicative that Mr. Headley, that there's nothing connecting Mr. Headley to this particular conspiracy.
So, Your Honor, Mr. Headley was present in the car. All of these conversations took place outside of the car. So Mr. Headley wasn't present for the specific exchanges or able to hear what Pollard was saying to the informant. So, Your Honor, we request that you reverse Mr. Headley's conviction.
Thank you. Okay. Okay, you can proceed.
Good afternoon, Your Honors. May it please the court. My name is Sheila Bautista, and I represent the people in this case. Your Honors,
So what in the record connects Mr. Headley to the conspiracy?
The context of why he was in the car. The defendant was in the lead car of a robbery caravan because he was part of this conspiracy. He had a prominent role on this team. He was a front seat passenger in the lead car of an armed robbery caravan on its way to steal 70 kilograms of cocaine. He didn't just happen to be in the car. He was in that position in the car because he was a trusted member of this conspiracy. In the case of People v. Edie, this court found that the rear seat passenger in the last car of this caravan, the court found that based on those facts, the inference could be drawn that he was part of this conspiracy. This is an even stronger case. The defendant's in the front seat of the lead car. He's sitting in front of a glove compartment with a gun. And the Edie case was a suppression case. This is a trial case. We have evidence. We have the testimony of the informant. We have the jury who heard phone call after phone call of Pollard, the mastermind of this conspiracy, saying he would be coming with an armed robbery crew. So when defendant and the rest of the crew showed up with Pollard on the day of the planned robbery, that whole context, all of that context supports the jury's inference that the defendant was part of this conspiracy and not in the car just because he happened to be there. With respect to the robbery conviction, the evidence fully supported the finding of the jury that this caravan, this armed caravan, was on its way to a robbery, and the only thing that stopped them was that the police officers arrested them before they could proceed. And of course,
Wasn't that exactly what happened in People versus Rizzo?
this is
I
different.
mean, how can you distinguish it? It literally is the same case. And the Court of Appeal said, good on the police for stopping it, but it's not attempted robbery because it's too attenuated. How do you distinguish it?
Rizzo was different because that was a crew of defendants who were trying in various locations to find their robbery victim, were unable to locate their robbery victim. There is no indication that it wasn't just the police arrest that stopped them from committing the crime. They tried to commit the crime, but they couldn't find their victim.
But isn't the import of that case that there has to be a real attempt, that it's not enough to be driving around? You have to show, I'm almost there and doing it, and once you stop someone in the car 100 blocks away, it's almost impossible for there to be a real attempt, right?
We have a real attempt here. We have a crew of 8 men in 3 cars, and each of those cars has loaded guns. They're on their way to commit this robbery. But for the arrest by the police officers, and of course the fact that this was a sting operation, it wasn't committed. In Rizzo, there was far. It wasn't just that the police officers stopped them. It's that everywhere they went, they couldn't find their robbery victim, which was different than in this case, where if they had.
But why is that distinction important, is I guess what I'm trying to say. Why does that matter? So what?
Because there's a difference between being unable to find the object of the robbery in the Rizzo case versus this case where, apart from the fact that it's a sting operation, if the circumstances had been as they believed them to be, they could have gotten to their location where they believed their robbery, the stash they were trying to steal would be. So that's the difference. In Rizzo, they couldn't find it. In this case, if the situation existed as they believed it to be, they would have gone to the location and committed the robbery. That's the difference between this case and Rizzo. And if the court has no other questions, we ask that you affirm the conviction.
Thank you. Rebuttal?
Yes, Your Honor. Beginning with Rizzo, the court's decision in that case did not turn on the fact that the defendants were apparently unable to locate their victim. They said that the line for attempted robbery, no attempt to rob can be made until the victim comes into sight, until you reach the presence of the victim. They did not say that the conviction was insufficient because maybe they never would have found the victim. But regardless of that, there are plenty of contingencies here that could have prevented the crime if it were real from being committed. You know, on page 14 of the respondent's brief, they talk about the specific plan, which was to intercept a shipment of drugs while it was being unloaded from a van into the lobby of an apartment building. And the informant repeatedly emphasized how narrow the window was, and if any small thing went wrong, they were going to miss the opportunity to do this. So if this was a real crime, there were plenty of contingencies that could have prevented it from occurring in the 100 blocks between the McDonald's and Riverdale. Briefly on conspiracy, a small correction, Mr. Headley was not in the lead car. The informant car was the lead car leading the way to the supposed robbery. The fact that he was in the front seat is immaterial. Everyone agrees that Pollard was the head honcho of the robbery, and he was in the back seat of the car. Mr. Headley was acquitted on the gun charge, which suggests that the jury did not think he was aware that there was a gun in the car, which did not belong to him. And the Edie decision involved a lower probable cause standard and also involved different evidence, and in particular does not involve the kind of phone record evidence and the other evidence that we submit supports our conception of the defense. So for all of those reasons, we request that you reverse Mr. Headley's conviction.
Thank you. Thank you both.
Thank you.
The next case is Ms. Rahi against Con Ed. Okay, you can proceed, Counselor.
May it please the court, good afternoon, Your Honors. Benjamin Goldstein on behalf of the plaintiff appellant. This case involves a defective condition on a New York City roadway. Specifically, it was a 7-box metal box that was owned and operated by defendant Con Edison. Specifically, it was the metal box along with the cracked and broken pavement surrounding it that caused the defective condition. The defective condition that was involved in this matter, as described in the corrective action requests that were sent from New York City to Con Ed, were, quote, the defective hardware and, quote, the loose and noisy boxes as part of this box. And those are found on pages 425 and 427 of the record. There was a lot of focus.
Can you tell me, because I know there was a lot of argument back and forth, did your client at her deposition ever testify that it was something other than the service box that her bicycle, that caused her bicycle to fall? And her, yeah.
Yes, Your Honor. So again, it seems like the focus here from the lower court as well as from the defendants is that our claim was that there was something wrong with the surface of the metal box, and that's not what our claim is. The claim is simply that by virtue of this cracked and broken pavement surrounding the box, it was impossible for that service box to be flush and sturdy against the surrounding roadway, which is why when she was asked, and this is in the record on page 196 or 197, when she was asked if there was any type of depression or anything of that nature that caused the accident, she indicated, I think so. Meaning, again, the idea was that she was riding down the street. She ultimately hits into this box. The box was not sturdy. The box was not up against the pavement, and that's what caused the accident.
Well,
and again,
and
that's...
Is
the
that what
box
she
move?
testified to?
Right?
I don't think that's what she testified to. That's
so,
not what she said, right?
So again, all the questions
Look at her deposition transcript, right? She says she fell because her wheel got caught in the middle of that groove. That has nothing to do with whether or not it was flush. That's what she said her accident occurred. So what is the relevance of that? First of all, when I look at the picture, it does kind of look flush, but okay, even assuming that that's not true, what's the relevance of that? Because that's not how she said her accident happened.
Sure. Thank you, Your Honor. I believe the testimony that Your Honor is referring to is where she indicates that there were grooves on the plate that caused the accident. Now, what's important to note here, and everyone agrees to this, and the pictures reflect that, is that the joints or the bolts that were on this metal plate were perpendicular to the way that she was riding. There was no groove or area on the plate itself that could have been what she was referring to. It's clear that what she was referring to was exactly that point, that as she's going from the surrounding roadway onto the metal plate, there was this unevenness, there was this depression, which is what her testimony was, and that's what caused it. Now, again, she was asked repeatedly if there are any defects on the plate itself, and the answer to that was always no, because there was never any claim here that the surface.
You don't have an expert that measures that so-called depression, do you?
We don't, and neither do the defendants, and that's part of what our claim is as well, is that the defendants never put forth any measurements, any expert testimony, and frankly—
That there wasn't a depression?
Correct, and to Your
That's
Honor's—
assuming that, okay.
To Your Honor's point, even the photographs that were submitted are frankly not the best photographs, and
Well,
I would submit—
the photographs, you can't tell any depression.
Well, I would submit that you can't see that it's flush either. And again, according to the corrective action request, which was frankly ignored by the lower court as well as by defendants, they indicate that the defect was it was loose and noisy when riding over it. And that's exactly the point, is that even if you theoretically could see how it was against the surrounding sidewalk, there was this imbalance that was caused by it.
Sir, if I can pick up on what Justice Scarpula raised with you, you don't implicate the 12-inch rule at all.
That's correct.
Okay. And as Justice Scarpula mentioned, or alluded to among other testimony, your client said she fell somewhere at the bottom of the rows of squares on the plate, and her front tire was on one of those 3 squares. So in a sense, she's critical of the design. She doesn't say there was an imbalance of the plate between the plate and the surrounding roadway, as we would see with a sidewalk situation where you can have an uneven sidewalk. She's not saying that. She's saying her tire got caught on the very grid of the service box.
If I could respond, Your Honor.
You may.
Thank you. Again, I would say that what she indicates is that she falls on the plate. And again, the testimony that's reflected on page 196 and 197 was that she was asked about any sort of depression that she felt. And again, this is a moving, not motorcycle, excuse me, a moving bicycle. So the fact that as she hits over the defect, she then continues for another, few inches, whatever it may be, that when she then falls, she's falling on top of the actual plate, doesn't indicate that, again, that the defect was the plate itself. Thank you, Your Honors.
Thank you.
May it please the court, my name is Dan Ratner. I'm representing Con Edison on the appeal. At page 86 of the record, the plaintiff was asked, how did this happen? Well, my tire got stuck in the plate and I fell. That's page 85. Asked if she was any part of the plate that was sunken or raised or anything else. She said no, there were grooves and my tire got stuck in it. Then she was asked if it had anything to do with the cracked pavement or anything like that, and she said no, I just got
And let me
stuck
just
in the
stop you there. The pictures clearly depict cracked pavement. There's no argument about that, right?
Right, and if she had testified that she didn't know what she fell on, and we wanted to draw inferences, maybe it would be a different story, but she had a specific description of what caused her to fall.
Did she testify at all that there was anything about a discrepancy between the plate and the surrounding?
No, she did not. In fact, she was asked, was it anything around the metal plate or next to the metal plate? No, it was stuck in the plate. It was the plate.
Did she testify at all about the plate being loose?
No, she didn't. No, she didn't. And I think what the counsel is referring to regarding some of these accident reports or car reports is the fact when cars were going over the plate, it would make a noise. There was no complaints about the weight of a bicycle causing that kind of an accident. People do fall off their bicycles when they go over certain surfaces. It's just a fact. And that's basically what I think the plaintiff described here. Thank you, Your Honor.
Thank you.
Good afternoon. May it please the court. Michelle Gelman for Respondent, Triumph Construction Corp. I will keep this brief as my colleague mirrored many of my statements. Most importantly, when questioned at her deposition, in particular at the record at 88 and 89, she was questioned specifically as to the alleged broken pavement and asphalt around the 7-door service box, to which plaintiff clearly responded, that was not the cause of her fall. It didn't have anything to do with that. There were several other spots in the record, in particular pages 75 and 76, 86 in particular, where again she was asked as to her knowledge of the cause of the incident, and again she clearly indicated the 7-door service box. Counsel for plaintiff has indicated there was a notice of violation with regard to that service box. That was in 2011, 4 years before this incident. That was rectified. Any other violations had to do with the pavement around, which, again, as counsel indicated, is not what is in question in this case, since it's clear from plaintiff's own testimony, it was a portion, in particular, a groove on the 7-door service box in which her bicycle tire was caught, and nothing to do with pavement on the asphalt surrounding it, nor was there anything loose, wobbly, or noisy. She was specifically asked about that with regard to the service box itself. Therefore, I respectfully request that the lower court's decision as to Triumph Construction be affirmed. Thank you.
Thanks. Thank you. Okay.
If I may, Your Honors, just to address very quickly the issue about the cracked pavement around the service box, what I would say is that, again, her testimony is clear that it wasn't the cracked pavement that she rode over that caused the accident, but the significance of the cracked pavement, and frankly, the significance of the 12-inch rule that makes it the responsibility of Con Ed is that, again, by virtue of that cracked and broken pavement, it was simply impossible.
I think part of the arguments that they're making is that what you're claiming is just not in her EBT. So honestly, it would be very helpful if you could tell us what sections of her EBT are you relying upon to say that something that other than just crossing over the plate, that there was some defect in the plate or the looseness of the plate or the cracks that affected the plate that otherwise caused her fall. That would, I think, be helpful.
Sure, Your Honor. So again, I would point to page 196 and 197 of the record. And I'd also just point out that, again, just because she wasn't asked specific questions at her deposition didn't mean that she needed to volunteer it. And again, all the questions that were addressed by my adversaries here related to questions about the surface of the plate itself, which again, our contention is a different animal over here. It wasn't the surface of the plate. It was simply the way that the plate was up against.
So, counsel, may I ask you, you're not contending that there was anything wrong with the plate, correct?
So again, vis-a-vis the surface of the plate, there was nothing wrong with the surface of the plate. The issue was the plate's defectiveness regarding the loose and noisy, correct?
Thank you.
And if there's no further questions, I'd ask that the court reverse the lower court's decision and reinstate the complaints. Thank you, Your Honors.
Thank you. Thank you both. And the next case for argument is Napoli versus James. Okay, you can proceed, Counselor.
Good afternoon, Your Honors. May it please the Court. My name is Salvatore Vidal, and I represent the appellant, Marie Napoli. Your Honors, before I address the Supreme Court's decision, I'd like to just note for Your Honors that plaintiff filed a motion to withdraw this appeal prior to today, and that is because of a motion to renew that has been filed with the Supreme Court due to new evidence that's been discovered. And that issue will go directly to this appeal that's pending right now, and that could render this appeal academic. Now, Your Honors, we asked this court to reverse the Supreme Court's ruling dismissing appellant's complaint against the respondents for the following two reasons. First, the Supreme Court improperly found the existence of probable cause. And second, the Supreme Court improperly found no basis for appellant to sue respondents pursuant to New York Judiciary Law 487. Your Honors, going to my first point, the issue that the Supreme Court raised on the first point was the malicious prosecution was probable cause. There, the court had a presumption of probable cause from the preliminary injunction, and that was based on error and demands reversal. That preliminary injunction was issued in August 2015. As of 2018, that preliminary injunction no longer stands. that preliminary injunction is no longer enforceable, has not been enforceable. Additionally, that preliminary injunction was obtained via fraudulent materials and without an evidentiary hearing. Mrs. Napoli had no opportunity to put on an evidentiary hearing to show that the allegations that were being made by the respondents in that preliminary injunction were false. But evidence has now shown, including a signed statement by Ms. Dennis, that the statements that were in that complaint and that were alleged by the respondents are indeed false. In fact, she specifically states, in her apology, she shows that it's been disproved that she claimed firsthand knowledge of other affairs. It's been disproven by her apology that Ms. Napoli was involved in the disappearance of her cat. She specifically disclaims that, and that's at the record at 46, that signed apology. And even most concerning is the statement that Ms. Dennis provides at the end of her apology, where she specifically said, had someone asked me these truths, I would have told them. What we know is the respondents, Mr. James, who was the attorney for Ms. Dennis and his law office, never asked Ms. Dennis whether these were true statements or not. Because had he asked, Ms. Dennis says she would have told him that they weren't true statements. And she specifically says that. There's been additional evidence that has been found that is part of a motion to renew, where the respondents were in possession of text messages and emails from Ms. Dennis, particularly an email where Ms. Dennis admits that she was treating at Pathways. And she provides the link to Pathways back in 2013. When you click on New York Pathways, it comes up right on the website. It's treatment for sexual addiction. That was a true statement that she was being treated for sexual addiction at that time. Additionally, it's been alleged that Ms. Napoli sent unwanted text messages to Ms. Dennis's then husband. Again, proven untrue. There's text messages of Ms. Dennis's ex-husband that say, please provide me the information. Please send me the information. Here is my email address. That is all pending on the motion to renew as well. And Your Honors, most importantly, dismissal of a malicious prosecution claim at the pleading stage, or even at summary judgment, is inappropriate when the question of whether a defendant had probable cause to pursue the underlying action is based on conflicting evidence. Here we have, at the very least, conflicting evidence. There was allegations that were made by Ms. Dennis that were proven false. And Your Honors, I see that my time is up.
Right.
Therefore, the appellant would respectfully request that the lower court's decision be overturned.
Thank you.
Thank you.
Good afternoon. Michael Furman on behalf of the respondent. Your Honor, just in the brief time that I have, the cases that are on point and for Your Honors to decide this case are the Facebook versus DLA Piper case. I think the Struve versus Bingham case is particularly on point. This is where in this court, it was a malicious prosecution claim that was dismissed.
Well, counsel, before you get to that, let me just address the first issue as to should we allow the appellant to withdraw her appeal because of the motion that's pending down in Supreme Court, the motion to re-argue, or renew, rather.
Well, those were motions that were I was surprised to hear that was even raised here. Those were motions that were decided before we appeared today. There was an attempt by this plaintiff to keep resuscitating this case. And the attempt here is to create some kind of new evidence that allegedly exists in order to revive the underlying case and withdraw this appeal. The plaintiff it's clear that because the Dennis case was finished, the plaintiff's attempt to seek revenge on Ms. Dennis for this affair is now continuing by extension against the lawyer. And so this thing will continue and continue. The plaintiff's machinations here to try to seek to withdraw the appeal are just an attempt to keep this thing alive and keep repeating lies like this sexual addiction issue, which is a complete lie.
Isn't it true that the motion to renew exists independently of this appeal and will be decided independently?
Of course.
Right, so whatever we do here doesn't affect the motion to renew, which will either be granted or denied.
Correct, and it will most likely wind up here. You'll most likely get a motion to re-argue this decision. It's just a never-ending battle. I would just, and I know I only have short, limited time, one thing that I would urge Your Honors to take a look at, it's in the record, of course. I would only talk about things in the record, pages 129 to 130, which are Ms. Dennis's explanation for why she agreed to voluntarily dismiss this case. We didn't mention it much in the appeal, but it gives you a real human flavor and appreciation for what's at stake here, why this thing will just continue and continue. So I urge Your Honors to affirm the court below.
Counsel, I'm sorry. Are you referring to Ms. Dennis's discontinuing the action in Nassau County?
Correct.
I see.
Yeah, and it's at pages 129 to 130. We, of course, refer to it in our brief, but we don't recite it. But I would urge Your Honors to read it. It's a very short, it's only 2 pages. Thank you, Your Honors.
Thank you. Rebuttal?
Thank you, Your Honors. I just have one short point. This case is not about revenge. It's about seeking the truth and getting that information. This case was dismissed on a motion to dismiss. That wasn't the proper procedure here in a malicious prosecution case. And what we've seen is there is additional evidence that shows that the respondents knew.
You can't really rely on the additional evidence. It's not in front of us. You don't want us to decide this appeal because you have additional evidence. I quite frankly don't understand that as a legal matter, having nothing to do with whether your client's doing this for revenge or not revenge, or she has pure motives. I don't understand, because the motion to renew exists independently of this appeal.
It does, Your Honor, but it's plaintiff's position, the appellant's position, that could render this appeal academic because...
And it could not, right? So why don't we just decide the appeal? If your motion to renew is granted, then it's granted. If it's denied, then your client has the right to appeal, and we're limited to consideration of this new evidence that you keep referring to. So I think procedurally, that's the best. That makes sense to me, personally.
Your Honor, I see my time is up. May I answer your question?
It's not really a question. It was a statement to you, but I'll let you say one final statement about it.
Thank you, Your Honor. I appreciate that. But being that because this decision at the Supreme Court wasn't based on all of the facts. There are facts that we believe show.
But we don't know that, and that's in your motion to renew, which maybe we will get a chance to look at or not, depending upon what we do up here. You know, we may agree with you, we may not agree with you on this appeal, and then we don't know what the lower court's going to do. But thank you.
Thank you, Your Honors.
Thank you very much. People versus Noel Brown. You can proceed, Counselor.
Good afternoon. My name is John Palmer, appearing on behalf of Noel Brown. The court denied Mr. Brown's unequivocal request to go pro se because it believed that Mr. Brown did not understand its warnings. The record, however, supports nothing but a knowing and intelligent decision from Mr. Brown to waive counsel and represent himself. Accordingly, we ask this court to reverse Mr. Brown's convictions and order a new trial.
Can we change directions a little bit? You have another argument about the inventory search. So the first thing I'm going to ask you about that is that preserved?
So, Your Honor, yes, defense counsel argued that this was an exploratory search without probable cause. And the court found that the seizure of the weapon upon its discovery pursuant to a valid inventory search, which the officer actually prepared an inventory in his memo book, was also valid. So the court found it was a valid search and a valid inventory list. But it was not. The people failed to establish that the officer conducted that valid inventory search, as the officer failed to create a meaningful inventory list, which of course is the hallmark of an inventory search.
Well,
Right.
counsel, the fact that he took photographs and made a notation inside his memo book, is that enough for this meaningful inventory list?
So, no, Your Honor, not in this case, as the photographs of the motorcycle show the condition of the motorcycle. They don't show the contents of the motorcycle. And also, the memo book, yes, he did list the evidence that he recovered from the motorcycle.
Counsel, may I ask you, did counsel below argue that there was no meaningful inventory list?
No, he did not argue that, Your
That's
Honor.
not preserved, right? We agree on that.
But the court did find that it was a valid inventory list.
Right, but your argument here that the reason why it's not valid is because there was no inventory list. He didn't, the counsel below didn't argue that, right?
Right. And if this court finds that it's not preserved, we ask the court to reach this issue in the interest of justice.
Counsel, is your understanding of an inventory search, would that be for anything that's in the police custody? Would you agree with that? In other words, the motorcycle and whatever is part of the motorcycle should be part of a proper inventory search, correct?
Well, it would, yes and no.
Okay, but the point is generally an inventory search is designed to safeguard the object, make sure it's not a danger to anyone, and make sure nothing gets stolen if it's returned to the defendant. Oh, I'm missing something, et cetera. I mean, I'm being overly simplistic, but that's generally what the purpose, correct?
Correct.
So would you think it's unreasonable that if they decided to give a bag to the passenger of the motorcycle to take home, I mean, if she had a license, she probably would have been able to take home the motorcycle, but putting that aside, so obviously that bag isn't retained by the police custody, correct?
It was not retained by the police, no.
Right, so then there would be no reason to have that bag inventoried if it's not retained by the police. So why would that be an issue here?
Because recording that occurrence, that he found the bag and returned the bag, would serve the purposes of the inventory search, which is to, safeguard property, prevent claims of theft against the police. And there's other cases, for example, Padilla, where the officer in that case, everything he did served the purposes of the search because he not only released the bag to the sister, who was also a police officer, but he recorded that occurrence in his memo book and had the sister sign it. So there was no doubt as to what happened to that bag. And there was no doubt as to that was a valid inventory search that was done for less rather than rummaging for evidence. And here, the officer only recorded the evidence that was taken in this case and nothing else that remained in the motorcycle, which would serve the purposes of the search. And that's what other cases have found, such as Walker, where it said, even a vague description, such as miscellaneous items, paperwork of contents of the trunk, for example, and what was found and turned over to the defendant in that case, that while not an ideal, served the purposes of the search and was sufficient constitutionally in that case. And because the prosecution has failed to establish that this was a valid inventory search, we would ask the court to dismiss Mr. Brown's convictions. Thank you.
Thank you.
May it please the court, Andrew Seawald for the people. I would just begin by pointing out that the defendant's arguments with respect to the inventory search are almost entirely unpreserved. As Your Honor had mentioned, he didn't argue below that the list that the police officers—
Well, counsel, assuming that we can get beyond the issue of preservation, on the merits, the officer had several items in his custody that was on the motorcycle, and he only included certain things that turned out to be evidence. How is that a meaningful search? I mean, meaningful inventory list, rather.
Well, as far as we can tell, everything that the police retained custody of was included on the list that the officer created. And And so that is a meaningful list.
I mean, in
And
his memo book, without respect to the pictures?
even just his memo book, I would submit, would be enough. I mean, the Court of Appeals has been clear in People versus Walker, People versus Lee, that even when a list is quote, not a model, it is still sufficient it can still constitute a meaningful inventory list.
Right, but so the question is, assuming that this wasn't a model, because there was at least missing the fact that that certain material was given to the passenger on the motorcycle and it wasn't recorded on the list, is that sufficient to make it defective?
No, Your Honor. First,
why not?
First, I would say that the point of the meaningful inventory list is for the police to have created some record of the property that they are retaining control of, that they're going to be responsible for it, they have the custody of.
Right, and it has to be done pursuant to some kind of procedure, which we only know based upon what he testified to, right? Because the other proof of procedure was not relevant to the time period. So we just have his memo book, we have his photographs, and the fact that he gave other items that he decided that he didn't think was important to record inside whatever list, because it was on the motorcycle also, that bag, right?
Yes, yes, Your Honor. But I would say that in Padilla, the officer's memo book said that and I would just note parenthetically that in that case, the inventory, I think, was a memo book, and the Court of Appeals found that to be a meaningful list. But in that case, the memo book noted that the officer had released some items to the defendant's sister. It didn't specifically identify any of those items, and that was acceptable, deemed acceptable by the Court of Appeals. And I would also just point out that with respect to this argument that the defense raised on appeal about the patrol guide section, when the 2016 version versus the 2013 version, they didn't raise that argument below at all. And the provisions regarding the officer testified that the patrol guide provision, in effect at the time of the search, directed the officer, required the officer to search the motorcycle thoroughly. There's no difference between the 2013 patrol guide provision and the 2016.
Well, actually, we don't know because we don't have the 2013 provision, correct?
Yeah, it was not put into evidence. That is correct.
But let me do the but question, though. But had a timely objection been raised about the patrol guide that was produced, that it was the wrong version, the people could have gotten the right version and put it in.
For sure, and the officer testified about the provisions in the patrol guide, and that the provisions, even in the 2016 version, were in effect at the time of the search, and those provisions directed the officer to thoroughly search every part of the vehicle. And defense counsel, in his reply brief, pointed out some difference in the 2013 version versus the 2016 version, having to do with consent, how to obtain consent from a defendant. But I would just note that you only get to consent under either version if the compartment can't be forced open without causing more than minimal damage. So any difference in the procedure or description of the procedure for obtaining consent between the 2013 version and the 2016 version is completely irrelevant. The operative provisions directing the officer to search the vehicle thoroughly, were exactly the same. So, and again, I would just reiterate that these arguments that the defense is relying on were completely unpreserved. So for all those reasons, I would ask the court to affirm.
Thank you. Right. Rebuttal?
Yes, Your Honor, I just have 3 quick points. As to the bag release, we don't have any record of that bag release at all, and we don't even know that there was just one bag here. As he said, he released a gas tank bag to the passenger, but had to remove a bag around the back of the bike before he started the inventory search. Further, Kempinski, the testifying officer, did not say what provisions were in effect at what time when he searched the vehicle. He just said he followed the patrol guide. Further, this court, of course, as you know, has full ability to review this issue in the interest of justice. And I think that is a valid use, this case is a valid use of that jurisdiction here. As this is a dispositive constitutional claim that is clear from the record, the people missed no opportunity to present evidence or make any arguments on the inventory list issue, as you know, they could not produce an inventory list that did not exist. And I would ask this court to dismiss the convictions here. Thank you.
Thank you. Thank you both. The next case for argument is Rooney versus DP Consulting Corp.
Good afternoon, Your Honors. May it please the Court. My name is Brian Isaac. I represent the plaintiff appellant respondent in this matter. Let me deal just with the 240 issue if I can, and I think I can simplify my argument so you understand what my claim is. My position is that the fact that there were 2 contemporaneous construction jobs going on at the same time only adds to the propriety of the 240 claim. If there was no construction at all, and my client was called upon to do exactly what he was doing at the time, our position would be we still have a 240 sub 1 claim, because as you well know, 240 sub 1 applies not just to giant building construction projects. It doesn't only apply to buildings, it applies to structures. And the Court of Appeals has long held, by my count, 1909 in Caddy against Interborough Railway, that a structure is, quote, any production or piece of work artificially built up or composed of parts joined together in some definite manner. I don't think it can be disputed that an elevator is a structure, and the issue that...
Sir, as I understand it, your adversary is arguing that what the plaintiff was doing was routine maintenance on the elevator, but it is your position that when he was asked to rig the elevator so it shouldn't open at the second entrance or rear entrance into the store or floor that was being renovated, which no one disputes is a construction job, the linkage between the separate work that your client was doing puts it under the rubric of Labor Law 241, correct?
That's correct. And my argument is that under your decision in Soriano, there's no basis to say that this is routine maintenance because it's not maintenance and it's not routine. Even if you assume that their argument has some merit, summary judgment motion. I didn't move for summary judgment. Obviously, I can't get summary judgment. There's a huge factual dispute, as you know, as to what happened. My client says he tripped on the platform and he fell into a pit. Defendant's position is my client's a faker. He's 260 pounds, he sat on the fence, and he landed on his rear end 2 feet. So I can't get summary judgment, but in a summary judgment motion where I'm opposing the motion, you have to take the best version of the facts that come to me. And I think there's just clearly a question of fact as to that particular situation. Moreover, if you look at the Joblon decision and you look at what the plaintiff did here, this is a significant change in a structure based upon the Court of Appeals decision in that case, as interpreted by this case in Paciello, Belding, and other cases such as that. As a matter of fact, I would ask you to look at the trial court's decision itself, page 20, paragraph 2. The trial court wrote it, look, I disagree with the conclusion, but the trial court did a very nice job, wrote a very, very cogent opinion, dealt with all the issues. This is what the trial court said about the work. Plaintiff's task of closing off the entry to the elevator with removal of the first floor door lock, putting in a junction box where the lock was, and running a connector through it was an, quote, alteration of the elevator that constituted significant physical change. Rather, the court must determine whether plaintiff was sufficiently engaged in the overall alteration of the first floor to bring his work within the scope of 240 sub 1. That recitation of what the plaintiff was doing, in my judgment, constitutes an alteration. I know we spoke about routine maintenance. I don't think it's a routine maintenance case, and I know we also spoke about repairs. Quite frankly, I don't see how this is a repair. It seems to me it's purely an alteration. And I'm going to actually go under my time. I did want to bring one thing to your attention. I thought your decision in Roth against Lenox Terrace was important. It's at 146 AD 3D 608. It does clearly deal with a repair as opposed to an alteration. But what I thought was interesting about the case, and I actually didn't know this case existed, you said in that case, quote, although plaintiff testified that the compressor contactor malfunctioned due to normal wear and tear, making it a worn-out component in an otherwise operable air conditioning unit, and that the entire replacement took only 20 minutes, he also stated this is not a part that would ordinarily require inspection, adjustments, or replacement, and that it generally lasts as long as the compressor and can last the life of the unit, indicating that it was not a recurring event and that the component was not intended to have a limited life. Under these circumstances, issues of fact exist as to whether plaintiff was performing routine maintenance or repair within the meaning of the statute. Seems to me Roth puts the lie to the claim that this is at all routine maintenance, and the fact that this job took, my client said two things, 35 to 40 minutes or 15 to 20 minutes just creates a question of fact. I have 2 more minutes on rebuttal, which I'll use to deal with anything that my adversaries say. Thanks for listening to me.
Thank you. All right, co-appellant?
May it please the court, Glenn Cummins with firm Omni Demers McManus, counsel for respondent appellant Edge. We would respectfully ask this court to modify the Supreme Court order so to grant complete summary judgment to Edge. As an initial matter, Edge is not a labor law defendant, and thus all the labor law claims against Edge should have been dismissed. Edge did not control plaintiff's work. Plaintiff's work had nothing to do with the sidewalk work Edge was performing. Plaintiff's employer was not a subcontractor, Edge, or DP. The Kelerakis case cited at our brief at page 14 stands for the proposition we're not a proper labor law defendant. I also would look to the Velez case that this court decided in 1997 to show that we are not a proper labor law defendant and that 200, 240, and 241 should have been dismissed. In Velez, the contractor was found not to be
So,
subject.
counsel, isn't there testimonial evidence that Edge was responsible? I mean, there's testimony. There may not be a contract, but isn't someone, one of the contractors testified that Edge was responsible for performing the sidewalk excavation, including the safety procedures, and if we believe plaintiff's testimony, he fell into that pit, right? So doesn't that raise an issue of fact?
I'm going to adopt those facts, Your Honor.
Okay.
I'm going to say, hey, you're going to find an issue of fact. We built that ramp. Let's assume that's true. Under Velez, it still would not matter because Velez, the contractor was not held responsible, even though they were the owner of the injury-producing tower hoist there, because the plaintiff was not working on that project. Just like here, the plaintiff is not involved in our project. He's nothing but a pedestrian to us. And so we cannot be a labor law defendant as to him. Even if we are a labor law defendant, it's not a labor law case. Plaintiff was not.
Wait a second. You're saying that if there are 6 trades in a project and you're responsible for the overall safety, the fact that that one guy is not doing your particular job means you're out? I don't think
what I'm
that's
saying
not what
is
the law is.
plaintiff is not working on our project at all. He's not involved with us. We don't know. He's a stranger to us. It's not he's a sub of a sub. It's not that we're the GC.
So why couldn't you be liable on 200 for creating a defective condition that somebody who's walking around him just like any other person?
Well,
Why would you
I'll be
not
happy to address 200 if you want me to attack it
yeah.
right now
Why-
instead of
why-
the
why can't you
alteration
be
there.
at
But I'd like to
200?
get back to the alteration. But as to 200, okay, and the common law negligence, we should have been granted summary judgment for that reason, for those. It's not a means and methods case. At best, it's a dangerous condition case, right? We can agree on that. We can only be liable if we launch the instrument of harm. We can agree on this, right? Plaintiff was well aware of what that ramp was. Plaintiff's own testimony, set aside anyone else's.
If you created the condition, then it's not a,
Look, there's a, the allegation is you created this thing that he fell into, right?
The allegation is that his left heel hit this.
Whatever, I mean, for shorthand.
So the
And you
dangerous
created a
condition-
dangerous condition. And we look at the picture, and there's this big pit with a little orange netting over it. To me, that speaks to whether or not there's an issue of fact as to whether or not you created a dangerous condition. If you are conceding that there is at least testimony, if not a contract, that makes you responsible.
I respectfully disagree. At best, the dangerous condition is the 6 to 8 inch height differential, the ramp to the diamond plate decking that he allegedly backs out of. But that's an open and obvious condition that plaintiff was well aware of. He testified he was well aware of it before the accident ever happened. We can't be negligent for a open and obvious condition. We can only be negligent.
that's not exactly true. If it's open and obvious, you may be, your duty to warn may be obviated, but you still can be liable for creating the dangerous condition.
I respectfully believe that here, where the plaintiff is well aware of the condition, and under the circumstances of this case, where he backs out, first looks under his right elbow, testifies, I do not look back, and I step back with my left. I hit something, we're going to assume for the facts of this case that he hits the ramp. At that point in time, he hit something that he knew was there, he knew was not defective at any point in time. He had been on it already. Respectfully, that's not launching the instrument of harm.
Well, if the ramp wasn't properly braced, in other words, it was lipped over the step of the decking that you described, apparently accepting the plaintiff's version versus other testimony to suggest he was leaning against some kind of orange netting and wood, and drinking coffee and fell, but putting that aside for a moment.
Of course.
If we accept the plaintiff's version that as he was stepping back from the elevator entrance out, that front entrance, and his heel got caught in between, I guess, the decking and the ramp that wasn't braced properly, putting aside the differential, that was the trip hazard that he claims caused him to fall into the, quote, pit, where each side debates how deep it was, and I'm not getting caught up with that either. But at least under 241.6, there are specific industrial code sections that talk about how to safeguard ramps and bracing and things of that nature. So on that basis, since Edge, together with DP, is responsible overall for the sidewalk excavation project, and therefore, as my colleague pointed out, it's an issue of fact as to whether a condition was created, or certainly they had notice of how the ramp was constructed in terms of the means and methods in that context.
Well, it's not a means and methods case. I don't see it as that at all. So if it's a dangerous condition case, as I said, it's an open and obvious condition. We couldn't have launched it. At worst, we gave rise to the ability. Let me find the exact language. I apologize. That we nothing more than give rise to the condition that may allow for this accident, but that's not.
But that's not what's,
doesn't give us a negligence.
That's not what's claimed here. And I think even if you're claiming that as a defense, there's at least an issue of fact about whether you, having built the ramp, did launch an instrument of harm. I'm not, for me personally, I'm having difficulty wrapping my head analytically around your arguments. That's not really a question, but we're going to study your briefs. Let's hear from the respondent, and you'll have a chance at rebuttal because you're a co-appellant.
Absolutely. Thank you, Your Honor.
Yes.
Good afternoon, Your Honors. Matthew Corcoran for SCIG 151 Hudson and Andrews Building Corp. Really quickly, I do just want to bring out something that my co-respondent brought up. I would not argue this was an open and obvious condition. The misleveling of the ramp and the elevator is one that plaintiff himself created. He acknowledged he left the elevator cab about 8 to 10 inches away from the platform in which he was standing so that he could reach components of the elevator to do his job. Just briefly, I disagree with the characterization of it as an open and obvious condition. Secondly, another point, these are two completely separate and distinct construction projects that were going on in the building at this time. SCIG LLC was doing a complete interior renovation to the first floor commercial space that they owned, while separately, Edge, and through separate contracts, separate contractors, no work overlapped, was performing a sidewalk excavation on the exterior of the building. Now, we would still argue that, according to the Pratt's case, plaintiff's work was not sufficiently connected to either project to afford him protection under the labor law, but if there's any argument to be made that his work was connected to a project, it would be the SCIG project. There's absolutely no connection to the sidewalk excavation project whatsoever in connection with plaintiff's work. And as for the argument, and as this court is, I'm sure, aware, we only moved for dismissal of the labor law claims before the lower courts. We have no negligence arguments or 200 arguments. As for the plaintiff's argument that he was not involved in routine maintenance, well, I think he's relying on a portion of the testimony from plaintiff and his employer deciding that this work was not pursuant to the general contract. It was a billable or invoiceable work. I don't necessarily think that that's
What would it be routine about it? If closing up, changing the buttons and closing up one side of the, let me stop that because he didn't do the closing up, but changing the mechanics of the elevator so that it could work, so that they could close off the elevator in order to do the construction and keep people off the interior construction of the site. What's routine about that?
Well, first, again, there's the significant connection argument on the part of the SCIG project. Separately, however, he didn't do this pursuant to any separate contract. He didn't have to get instruction from anybody who was at the site. He didn't install anything. He didn't take out anything. And there are many cases we cited in our brief.
That's not routine, what he was doing, to get it ready so that they could do construction. That's not routine.
I mean, I would argue.
You don't call it, the elevator, it's working slowly, it's stopping on the second floor when it shouldn't, the buttons aren't. How is that routine? I just don't understand the argument.
I would argue perhaps not in the dictionary, bare bones Oxford English Dictionary definition of the word routine, but under the law. We cited several cases through pages 14, 15, 16 of our brief that had similar or if not even more extreme situations that the court deemed were also routine maintenance. Threading wires through existing holes. A technician who was injured in a fall while he was splicing fiber optic cables to bring telephone service. These are all working with conditions and equipment that's already pre-existing in the building, and the first department has determined that effectively just flipping a switch or switching something around that already exists is routine maintenance pursuant to those cases. Unless the court has any other questions, I'll rest on my papers.
No, thank you. Rebuttal?
Yes, Your Honor, I'll be brief.
Can you address the statutory agent argument with respect to not 200, but 240 and 241-6?
Sure, it's simple. It's Walls and Russin, which are the major cases, which of course you know, where the injury-producing event falls within the ambit of the responsibility of the defendant entity. Let's call them a subcontractor, because that's what we have here, Judge Scarpula. If that entity has the right to control what's going on, that entity becomes an agent. The defendants are compartmentalizing my claim. My claim isn't only that the platform that they used caused the plaintiff to fall, but that after the plaintiff fell, he went into the barricaded area, which was supposed to be barricaded. By the way, not just to protect construction workers. I believe that the owner defendant said on 1389 to 1390 that the fencing was designed to protect tenants because they had to use the back area to get in. He's a labor law defendant because that's part of the claim. And you can have more than one proximate cause of an
No,
accident.
but let me just ask you, how do you address the council's argument that these are two separate projects?
Oh, it's simple, statutorily. 2.5 of the labor law, 2.7 of the labor law, Gibson and Morkowski. Labor law protection extends to anyone who's at a site who's hired by someone, and 2.5 says that someone is an employee where that person is permitted or suffered to work.
So
My
it's your
client,
position that that's not relevant because they were both at the same project doing some outside, some inside. Okay.
yes, correct.
All right.
I don't have anything else if you don't have any more questions for me. Thank you.
All right, rebuttal from Edge.
Phrasing the question is one of routine maintenance. It doesn't really do justice to what this case is about. It's really, is the plaintiff engaged in an enumerated activity which would require alteration? And by plaintiff's own testimony, he simply removed a door lock, put in a junction box where the lock was, and then tied back the wires. It took
So,
him 10
counsel,
to
let
15
me just
minutes.
ask you, wasn't that to facilitate the renovation? It wasn't just because someone felt like closing the door that day, right? It was specifically to facilitate the renovation of that space, correct?
And that's where we get into the court's very good analysis of the Pratt's case. So we know that he didn't really perform an alteration. So then it's got to be tied into that project that Skid is doing.
Was it not?
But no, not.
You just
not
closed the
under
door because
Pratt's-
someone said that day, oh gee, I feel like having the elevator door closed that day?
Under
That's
how?
not the testimony, right?
Under the court's analysis in
No, but I'm
Pratt.
just asking, in this case, he testified, I closed that door so they could do the renovation, right?
He closed that door so that the door would not open into the renovation. That is absolutely correct. That is
And
what
we
happened.
accept that at this point anyway, as what he says, and that's what he was intending to do. Let me ask you this, what about the separate bill for the work? It wasn't under the regular contract, right? I hire Otis Elevator, I pay him 30 grand a month, they do all the routine maintenance, but that wasn't this, right? There was a separate bill for this.
Right, which
Doesn't
is
that
not
at least
unusual.
raise an issue of fact as to whether or not this was regular routine maintenance or
Well, as a
something else?
preliminary matter, there's no evidence of an actual physical bill for this
Well,
work.
there's testimony,
Okay.
which is perfectly good. Nobody likes it, but
But-
testimony is perfectly good evidence,
It's
right?
perfectly good. It's also good that he calls it a service call. And but importantly is, what was the work he was doing? It wasn't an alteration in and of itself, and under the court's very good Pratt's analysis, he doesn't fall under that work either.
So,
it
but
can't be
again,
a
doesn't it
240
at
case.
least raise an issue of fact that they charge separately and not under their regular maintenance contract? Are you denying that you're saying that doesn't raise an issue?
I have to adopt that fact. I got to give him every reasonable inference. I got to adopt it. But even if I adopt it, it doesn't change the analysis. Thank you, Your Honors.
Thank you. Thank you all. Padilla versus Touro College.
Good afternoon, Your Honors. My name is Salvatore Agosta. I'm here on behalf of the appellant, Josio Padilla. My appeal concerns three basic parts. The first is that we're arguing that the defendant, Touro College, did not meet their initial burden on summary judgment. There's no evidence as to a lack of notice, both constructive and actual. Touro did not submit any evidence as to duration of the condition at issue, the origin or the creation of the condition at issue, inspection of the condition, and there's frankly, there's no expert opinion aside from the plaintiff's expert as to the safety of the practice or the safety of the condition itself. Now, the condition itself, the condition at issue is a five to eight panel pile of soundproof drywall that was leaning vertically against a wall in a hallway. The plaintiff testified that this hallway was unfinished, but that the walls are partially completed, and that's why the sheetrock, well, that's where the sheetrock was leaning. Defendant Toro's witness also confirmed this was a hallway and a passageway, as the thing that plaintiff was working on, I should rewind, plaintiff is a security technician. He's installing a security system. He has nothing to do with the installation of the walls or the sheetrock.
As you describe it, the sheetrock that was against the wall wasn't, whether it was obstructing the hallway or not, that had nothing to do with the accident here, right? The accident had to do with your client trying to get access to the wall behind.
Yeah, he's getting access to a hole that has a card reader in it that he was working on a few days or before the accident.
So whether the hallway was obstructed or not is somewhat irrelevant to the accident in this case.
Correct, Your Honor. I'm kind of forced to be making this point because the lower court said that it didn't occur in a hallway and dismissed the 241-6 claim on that regard alone.
Well, it didn't, but it had nothing to do with the hallway, so it's irrelevant, right?
It is, I agree.
Okay.
And so I guess I'll
But
focus.
that doesn't mean you get a revival of that. It didn't happen.
I agree. I
It
think
wasn't related to a hallway, so any violation that had to do with a hallway is completely irrelevant. You can't proceed under that.
Agreed. I think we should
Okay.
proceed under 241-6 under the rest of 241-6, which is about the proper storage of materials. It didn't really matter that it was in a hallway or not. 241-6 still applies. But the lower court decided that 241-6 did not apply because it factually found that this did not happen in a hallway. This was not argued in the lower court in the motion practice. So I'll rewind back to my initial burden. So this condition was unsupervised for 3 hours, according to the plaintiff. The deposition of the general contractor confirmed that he was the project manager. He believed that the condition, as it was described by the plaintiff, would be dangerous. He said that he observed drywall being left on the construction site unsupervised while the workers were on break. And according to the regulations about drywall storage, the OSHA and the ASTM standards, they confirm that this is an improper way to store drywall and that this is not considered stable. Lower court made another factual determination about the condition. It said that it was stable until plaintiff touched it. Plaintiff testified that all he did was try to move the boards a little bit, and they came and collapsed on top of him. The court thought that that was stable. So, especially in the light of all the other evidence, we think that there is not enough affirmative evidence to prove, as a matter of law, that this condition was not dangerous or that the practice of storing the drywall that way was not dangerous. The second point, I'll try and be quick, falling objects. The respondents are arguing that this is not a fallen objects case. The lower court agreed with them. The lower court said that the object only fell 4 feet instead of 9 feet. There's the Walensky case in the Court of Appeals that says that the level that the object is on and that the plaintiff is on is of no consequence whatsoever. The calculation is based on the force of gravity, the weight, and the potential harm. Here, these sheetrock boards, when plaintiff attempted to move them, there was no safety device. They were not on a cart. They were freely leaning. They fell. They injured him. That was an application of gravity that caused harm on a heavy object. And as I mentioned before, 241-6 does apply. I agree with Your Honor that it has nothing to do with whether it's in a hallway. It has to do with the proper storage of the materials. The statute says the materials are to be stored in a safe and orderly manner, stable under all conditions.
Okay.
Thank you.
Thank you. All right. Appellant T.A. Joy.
Good afternoon, Your Honors. May it please the Court, Irina Kravchenko, representing Respondent Appellant T.R. Joy. I will focus on my argument as the appellant with respect to contractual indemnification, and I'll allow the other respondents to address the 240 and 241 claims. With respect to contractual indemnification issue, Toro does not dispute, and the Supreme Court correctly held, that the provision in the agreement between Toro and TR Joy was extremely broad. It encompasses Toro's negligence, and it does not contain a savings clause. Therefore, it is in violation of GOL. However, the motion court erred when it held that it's enforceable in this case as a matter of law because Toro is free from fault. This conclusion is false for a number of reasons. In leading to this conclusion, the court based its opinion erroneously upon its belief that this is a means and methods case implicating the means and methods of work standard. However, all of the parties, including the plaintiff, including Toro itself, agrees that this case implicates a dangerous condition on the premises standard, which calls for a different analysis. Plaintiff unequivocally and repeatedly stated that the sheetrock had nothing to do with his work, that he wasn't using it as part of his work. And Toro, and this is a quote argued below, that it is axiomatic that the accident at issue stems from an alleged dangerous premises condition, i.e. sheetrock or sheets of sheetrock stacked against the wall as opposed to the means and methods of work. And that is on page 1403 in the record. Given the parties' unanimous opinion that this is a means or condition on the premises case, the Supreme Court improperly misapplied a different standard and found Toro to be free from fault. To the extent that Toro decided to argue this for the first time on appeal, now having obtained this favorable, albeit improper decision, this argument is not preserved for this court's review. Now, assuming that we do get to the actual determination of whether this is a means and methods or a premises case, the facts and the case law unequivocally shows that this case implicates the condition on the premises test. Again, plaintiff testified the sheetrock was not used for his job. It did not belong to TR Joy. He did not need it to do his work. In fact, he unequivocally stated that the work he was doing was 5 to 7 feet away from sheetrock. So even to the extent that he decided to look at anything, he wasn't supposed to work in the area. He also acknowledged that nobody told him to move the sheetrock. Because the sheetrock was present there, it had nothing to do with plaintiff's work whatsoever. It cannot be found that it resulted from means and methods of his work. In this regard, this case is analogous to case law emanating from this court where masonette fell on plaintiff, where a piece of pipe saddle detached from a ceiling, all of which employ the condition on the premises standard. To the extent that Toro maintains that this is a means and method case because plaintiff actually had to pull on the sheetrock for it to fall, it is our position that this does not change the applicable standard. It doesn't change the fact that the sheetrock presented the dangerous condition. It merely goes to show the plaintiff was comparatively at fault, or even more so, that he was the sole proximate cause of the occurrence, which was another argument that we made. At the very least, however, and this is as this court has held recently in Herrera versus 2146 Nostrand Avenue Associates LLC, 9383 for 21. This is a 2021 case. Judge Schulman was actually on that panel. This is a case that involves both means and methods and the condition of the premises. This is the absolute minimum. In that case, the plaintiff fell when the platform from a scaffold fell through the frame. And the court held that the means and method part of it was the fact that plaintiff was using another trade scaffold. However, it also held, and I quote, the presence of a defective scaffold on site that is usable constitutes a dangerous condition that the property owner and general contractor may have had authority to remedy. The same exact analysis should be applied to this case. The sheetrock was present on site. It created a dangerous condition, and even if plaintiff's work or his decision, unilateral decision to move same had anything to do with it, so did the scaffold. Having established that this is a premises condition case, the Supreme Court incorrectly found that Toro cannot be is free from fault as a matter of law because it is uncontroverted, and actually there is another finding the Supreme Court made that Toro did not establish that it lacked notice of same. In addition to that, the testimony from plaintiff and his supervisor showed that the sheetrock was present in that condition for multiple hours from the morning until 2:30 p.m. Therefore, it cannot be established as a matter of law that the contractual indemnification provision is enforceable. Thank you very much.
Thank you. All right, let's hear from respondent Touro College.
Good afternoon, Your Honors. May it please the Court. Joseph Orlando with O'Connor Red Orlando on behalf of respondent Touro College, the premises owner. Let me start by saying that this is a means and methods case and not a dangerous condition case. And the reason I say that is because the sheetrock, the stack of sheetrock leaning against the wall, 5 to 8 pieces of 4x8 sheetrock leaning against the wall, did not fall over on their own. They fell over when plaintiff placed his hands on the sheetrock, both hands, and attempted to move the sheetrock away from the wall so that he could get behind the wall to do some work on the wall. This accident was a result of the way he chose to perform his work as opposed to a dangerous condition on the job site.
Counsel, I mean, isn't that really oversimplifying it? The fact that this sheetrock and the way it was stored, and that's the dangerous condition. The fact that he had to move it to do his work, that's secondary. It was stored, and he had to get to the wall behind it, right?
But it was not being stored. It was actually being installed by sheetrockers working in that hallway at the exact time plaintiff was there. Plaintiff himself testified that the sheetrockers were working near him at the time of his accident. And the project manager for the general contractor confirmed that when he came up to the scene 10 minutes after the accident, he saw sheetrockers working 50 feet away from where the accident happened. So it was not being...
But he himself wasn't working with the sheetrock.
Correct.
Right?
He was not working with the sheetrock. But the sheetrock, by plaintiff's testimony himself, was stable, was not moving, not shifting, was not falling over before he put his hands on it, Judge.
Did the plaintiff had an expert affidavit down below?
The plaintiff submitted an expert affidavit, which I submitted to the court, should not even be considered because the plaintiff's expert did not provide his CV as part of his affidavit. He did not profess himself to be an engineer licensed in New York. He did not profess himself to be an OSHA certified safety inspector. And also his conclusions were based on facts that were not even in the record. He put into his report that there were 30 sheets of sheetrock when plaintiff himself testified there were only 5 to 8 sheets of sheetrock at issue. So his conclusions were based upon misstatements of fact, and his affidavit should be dismissed entirely, which is what the lower court did. Now, as to the means and methods, if the court agrees with the lower court that this is a means and methods case, my client did not supervise, direct, or control the plaintiff's work whatsoever. There's no evidence to the contrary. Plaintiff himself testified that all of his directions and instructions came from his employer.
But if it determined that the stack of sheetrock, which was not flat on the floor, but put against the wall and fell on him because of movement and it wasn't properly secure, arguendo, just assuming, then that would create an elevated risk here, a gravity-related issue, which would make your client a statutory agent under the law, even if you didn't control the means and methods, correct?
I would disagree that this is...
I mean, you could disagree that it's a 241 case, but assuming arguendo, based on case law, whatever, we were to interpret the manner in which the sheetrock was in that hallway and the nature of how it fell on him, et cetera, putting aside whether he contributed to it, I'm not going there right now, you would agree with me, sir, that that would make Turo a statutory agent under 241.
If the sheetrock was positioned on its short end and it was 8 feet in height and it fell over, I would agree with you.
Well, wasn't there something in the record that
the
sheetrock was not stored flat, but was leaning against the wall?
It was leaning against the wall, but on its long end, the 8-foot long end, so that it was only 4 feet in height. So that's not enough to trigger an elevation differential under the Labor Law 240, Your Honor. There is a case from the 3rd Department and the 4th Department right on point that are persuasive here. Wiley from the 3rd Department, sheetrock leaning on its 8-foot long side that falls over onto the plaintiff. And the case of Millard from the 4th Department, same scenario, sheetrock leaning against something on its long side, 4 feet in height, falls and breaks the plaintiff's leg. And both courts held 240 was inapplicable because there was no height differential.
Yeah, how do you square that, though, with our First Department cases, which seem to go the other way when it comes to sheetrock leaning up against a wall? And that would be Rodriguez and the Colin case.
All right, so the Rodriguez case involved sheetrock that, as I was mentioning to Your Honor, was leaning on its short end such that it was 8 feet tall in height, and that sheetrock was actually on top of a 2-foot block. So in total height, it was 10 feet, much higher than the plaintiff in that case, who was 5 foot 8 inches tall, and it fell over onto the plaintiff from a distance of approximately 4 feet, which is about the same height that the pipes fell over on the plaintiff in the Court of Appeals case of Walensky. So there was a height differential in both Rodriguez and Walensky that triggered 240, but in this case, the sheetrock is below the plaintiff. It's 4 feet in height. Plaintiff is 5 foot 6 inches tall. There is no height differential according to the case law, controlling case law in this state.
Okay, thank you. All right, let's hear from All-Pro.
May it please the court, David Metzger for the second third-party defendant respondent, All-Pro. I'll be brief. There was no affirmative relief sought against my client in the court below, nor did we make any affirmative motion below. Our client, I don't believe, is even mentioned in the decision. So there's nothing that directly involves us with respect to the appeal, but we did join and submit papers supporting Toro's position, which I think has been explained. I would just like to add one thing, just to counter something that the plaintiff had testified to, or not testified, that the appellant had indicated. He made a gesture to indicate that it was just the slightest of a touch that caused this sheetrock to fall. The plaintiff had testified that he grabbed multiple pieces and tried to lift them all out at the same time, record at 537, and used both hands to pull it. So this was a very stable situation. It would have been just it's equally stable if it was on its lying flat and he tried to move it. He could have hurt himself. It's the same thing. It was a stable pile of sheetrock, and it was the plaintiff and his actions that resulted in this incident. Thank you.
Okay, thank you. Okay, rebuttal from Padilla.
Thank you, Your Honor. At the time of the accident, the plaintiff testified that at the time of the accident, the sheetrock workers were approximately 100 feet away from him. The sheetrock was there.
So, counsel, what is your argument with respect to the height differential? And how do you distinguish the second, third, and fourth department cases on that issue?
Yes, well, taking Rodriguez and reading the Court of Appeals cases that come before it, there's no difference between where the base of the object is and the top of the object is. And the Walensky case is very clear that
Won't you agree that there are second, third, there are at least third and fourth, and I think second department cases that go the other way? That say leaning on the side and it falls down is not a height differential? I think I'm thinking of Seals. I'm thinking of some other cases. How do you distinguish those?
No, Your Honor, I'm not familiar with the other department's cases in terms of the height differential.
So the one case we had before, like this month, in this case, in this department, was they were up 2 feet, and then they were straight up and down. They weren't horizontal. Horizontal, right? So the cases in the other departments, they were horizontal, exactly how your plaintiff presents it. So again, how do you have any distinguish from
Yes,
that?
well, all of these variables are not dispositive to the calculation.
So you're saying it's an issue of fact?
Yes.
Okay.
I wanted to mention that expert testimony coming from the plaintiff on a motion for summary judgment is not as important, especially in this case, as it should be coming from Toro to explain the safety of the condition that we're talking about, to address how the OSHA standards don't apply, to address how the ASTM standards don't apply, to talk about how it might be safe to store the sheetrock the way they did. And lastly, I would like to just read a short quote about absolute liability when it comes to 241 cases.
You're reading it from a case? Do we have the citation?
Yes, Judge.
Your time is up. You don't need to read a case to us. We're perfectly adept at reading cases. Okay.
Thank you, Your Honor.
That's one thing I know we can do. Thank you.
Thank you.
All right. Wait, don't go away, sir. We still have one rebuttal, right?
Yes.
Right. Go ahead, from T.A. Joy.
I would just like to point out that Torres counsel made a misrepresentation with respect to why plaintiff was moving the planks. He indicated he did it in order to do the work behind them. However, the record shows otherwise. Plaintiff unequivocally testified on page 602 in the record that he did not have to move the drywall to do his job. He also stated that he was working in a different area altogether on that day, and the cables behind the plank were already completely finished. And this is in pages 290 and 601 in the record. That is all. Unless the bench has any questions, I'll rest on my briefs.
No, thank you. Thank you all for your arguments. Mara versus Long Island Airline.
Good afternoon, Your Honors. Douglas Latto on behalf of the appellant plaintiffs from the law firm of Spicer Krause. If it pleases the court, I would like to move to have Bradley Stoll from the law firm of Katzman, Lampert, and Stoll argue the appeal. He has been admitted pro hac vice before this court, I believe in November of 2021, and I believe Your Honors have that order allowing his pro hac admission. Thank you.
Thank you. I'm going to grant your application.
Thank you, Your Honor.
May it please the court, good afternoon, and thank you for indulging my application to appear today. This wrongful death and survival case arises from an airplane crash that occurred on June 2nd, 2018, between 1 and 2 miles into the Atlantic Ocean south of Amagansett, New York. The origin of the trip was from an island community in Newport, Rhode Island, and it was destined for East Hampton on the eastern edge of Long Island. This appeal arises from the lower court's denial of the plaintiff's motion to apply maritime law to this case. The plaintiffs moved to apply maritime law because the United States Supreme Court's two-part standard is met in this case. The functional difference between maritime law and New York law is that the former maritime law permits recovery of loss of society damages, whereas New York law is more pecuniary. The issue before the court are two aspects of the lower court's opinion. First, the plaintiffs respectfully submit that the lower court did not articulate the legal standard accurately and based its opinion on a narrowing of the standard. Specifically, the lower court said plaintiffs have failed to prove, but for aviation, this voyage would have been performed by a seagoing vessel. That standard narrowed the analysis too much. And the other part of the appeal that we've challenged is the factual record upon which the lower court made its determination that the predominant way to access the eastern edge of Long Island from Rhode Island is through automobile. That factual determination was made upon just the affirmation of the defense counsel.
I think you indicated that there's a two-prong analysis for otherwise determining whether maritime law would apply in this case. And can you tell us why you think that your client meets those two prongs?
Yes, Your Honor. The first,
and what those two prongs are?
Absolutely. So, dispensing with my introduction, the first prong is whether or not the tort or the wrong occurred over navigable waters. That part is met. The lower court confirmed it was met, and I believe that the defense has not disputed that this accident occurred over the Atlantic Ocean.
Right, the plane went down in the Atlantic.
Yes, Your Honor.
So if a plane was flying over Manhattan and crashed into a lake in Central Park, would you view that as navigable waters? I mean, that prong as being a win-win for you in terms of the analysis? Is that the same as what the Supreme Court was addressing in executive jet when you're talking about a plane going over the Atlantic Ocean from here to Europe?
Actually, in executive jet, the Supreme Court clarified that Your Honor's example would not constitute maritime law. Executive jet dispensed with the pure location test that was previous, where if it occurred over navigable waters, and I'm assuming in your hypothetical that the waters you've identified would be considered navigable. And the Supreme Court for airplane cases invoked another standard, and that other standard is what we are here about today, which is if the flight bears a significant relationship to traditional maritime activity. That is the second standard that we're dealing with. And that standard is, the Supreme Court instructs that we address that standard in two ways. First, we identify whether or not the event can have a disruption, have a potential disruption to maritime activity. And second, whether the function of the airplane is something that was traditionally performed by seagoing vessels. And I'll explain the latter first because it was the lower court's opinion on the second prong which was dispositive of this case. So first, dealing with whether or not this flight was fulfilling a function traditionally performed by seagoing vessels. That requires a factual record. And what we presented to the lower court was the history of ferry service between the New England coast and the eastern edge of Long Island. We presented a Connecticut historical study by the Connecticut Humanities, which is an affiliation of the National Endowment of Humanities.
But I just need to kind of go back, especially because you're going to run out of time.
Sure.
So the second prong, as I understand it, is that you need to show that the particular travel here has requisite nexus to maritime activity. Isn't that the second prong?
Well, it's
Navigable waters, one, and then the nexus, two, right?
Correct.
Isn't that executive jet?
Yes, Your Honor.
So what, your claim is what? Because travel could be between these two locations, could be by boat, that otherwise that satisfies that nexus? Is that enough?
No, not in the sense of how you've articulated. The way that I would present it to the court is that this function of this airplane was connecting people between coastal cities on New England to an island, Long Island, to the eastern coast. The unique geographical features of Long Island are such that historically and traditionally, that voyage was done by boat. And that is where we get to the second prong of whether the aircraft was...
May I ask you this one last question? I know I see a red light.
Yeah.
It's not just boat, right? It always, no matter what, it always had some land component, correct?
Yeah, I think any...
So you can't say it was traditionally a boat trip. It was, even in your examples, it was a boat and land trip.
There's always a component of a trek over land to get to your vehicle to make
Well,
the
that's
transport.
not just it. It's not, I'm not driving from my house to that. It's more than that, right?
In this case, it's more than that. We would be going from Rhode Island to the ferries and then making the journey to Long Island. But this accident occurred in that cross-ocean voyage to get from point A to point B, across the Atlantic Ocean, not from Europe to here.
We all agree that first prong is met.
But as far as the second prong goes, it's that voyage coming from southern New England to the eastern edge of Long Island, which triggers the second prong.
Is that the only nexus to maritime activity? In
Well,
other words, this wasn't related to commercial fishing or
That's where we get
fishing?
That's where we get to the national policy of how the courts have said the second aspect of this second prong is whether it has the potential to disrupt maritime activities. Example, two private aircraft collide over navigable waters. They interrupt shipping lanes. The shipping companies want to sue whoever's responsible for that, but if state law doesn't permit it, say a statute of repose or statute of limitations.
Doesn't it, by reading nexus as broadly as you do, and you're asking for a broad analysis of that, doesn't that somewhat vitiate the necessity of the second prong? And we just really are back to what Executive Jed said was not right, which is just the fact that it's over waters or happened in over navigable waters is sufficient.
I believe the two prongs counterbalance each other. When we look at the first prong, the potential for disruption, that shows the national policy, that maritime commerce is so important. We're going to have private accidents implicate maritime under a very broad nexus standard if it has the potential. United States Supreme Court, Sisson v. Ruby, the Foremost case, those cases state specifically that you only have to show more than a fanciful chance of disruption. That, and two courts have held that airplane crashes in the water, Foremost at note 5, and then Bell Harbor, the Eastern District of New York, said, yes, that can interrupt. But to get to your question,
I thought that answered my question. I'm going to give you time on rebuttal because you're way over your time.
thank you, Your Honor.
Let's hear from your adversary, but thank you.
May it please the court, my name is David Lowe, and we represent the defendant respondents. The first thing we wanted to...
Please tell us your analysis of the second prong, because let's just get to the heart of the dispute here.
Well, the second, I think in order to analyze the second prong, we have to go back and look at Executive Jet very specifically. And what Executive Jet was pointing out, was focused on, was in what circumstances does an aviation tort be involved with Admiralty and Maritime Law jurisdiction? And Admiralty and Maritime Law really has nothing to do with this case, Your Honor. Admiralty and Maritime Law is about general average, about limitation of liability, about maritime liens, about collision, elision. Those are terms that have nothing to do with this particular case. And what Executive Jet stood for was, if we are going to extend Admiralty and Maritime Law to an aviation tort that occurs, albeit on navigable waters, we have to be very, very careful about it, because the exceptions, that is what he's trying to argue, will subsume the rule.
So, which was my question to him. So you're advocating reading that nexus requirement more broadly, or actually...
Exactly. And I also want to point out about Executive Jet too, Your Honor, is that was a flight from Cleveland. And Cleveland, you can actually get to New York and or Boston, for that matter, by sea. Because traditionally, if we want to follow what the plaintiffs are advocating, it was as a historical or traditional record, is that you can utilize the Erie Canal. The Erie Canal...
Right, I was going to say, I don't know how far you get with historical, because if we go back to time in history, a boat was the major way of getting around from any place to any place in the United States. And yes, the Erie Canal, I didn't think of that as an example, but that is an example. But even this route, certainly in the 1800s, the ferry route was more popular than now going by automobile.
That's correct, Your Honor.
Right.
And we want to also point out that it's an issue with respect to air travel within the continental United States, which is what Executive Jet was really focused on. And we would argue that a flight from Newport to the eastern edge of Long Island is really just travel within the continental United States. If we're going to focus on...
Well, it doesn't matter. I mean, I believe that the plaintiff raised this, you know, that to bring up evidence about the commercial and recreational fishing activity off the eastern coast of Long Island. Does that in any, and the destination to which this plane was going, does that in any way impinge on the analysis of the nexus factor?
Yes, it does, Your Honor. So
Okay, how?
Okay, so there are 3 Supreme Court cases which talk about maritime torts. That's Grubart, Sisson versus Ruby, and then Foremost Insurance Company versus Richardson, okay? Grubart is, they were basically putting a piling in the in the Chicago River. They punched a hole in a basement and effectively flooded all of downtown Chicago. They ultimately ruled that there was Admiralty and Maritime jurisdiction, because even though putting a piling into the Chicago River had a potential effect on maritime commerce. That was the focus of it. Sisson versus Ruby was talking about a fire of a berth vessel that spread to the rest of the marina. So the question was whether or not Admiralty and Maritime Law would ultimately apply to that particular dispute. And the argument was ultimately, which they agreed with, was that a fire on a marina, on a navigable waterway, could have a potential effect on maritime commerce. So again, they found for Admiralty and Maritime Law. Here, Foremost Insurance was basically a collision between 2 pleasure craft on a river in Louisiana. So the question became, is it something that would be subject to maritime law, even though it wasn't something that was specifically commercial in nature? And they ultimately concluded because it had to do with the manner in which vessels are navigating within a navigable waterway, they ultimately found for Admiralty and Maritime Law. Here, we have a plane that crashed, and we would argue 1 mile from the coast, really has nothing to do with maritime commerce. It's not something that would affect fishery or any sort of commercial traffic. Yes, do commercial vessels travel past the southern part of Long Island to get to the port of New York and New Jersey? Yes, but that's many, many miles off the coast. It really has nothing to do with what really happened here, which is just a air crash, which resulted in some deaths, which are very unfortunate, but it really has nothing to do with maritime commerce per se. So for all those reasons, we think that the lower court was correct in circumscribing the nature and extent of Admiralty and Maritime Law here. So,
Thank you. All right, we'll hear some rebuttal, counsel.
thank you.
Thank you, Your Honors. I want to advocate where we draw the line on the second prong so that I can address the court's concern that we are not opening the floodgates to any and all flights over a navigable water. And that limitation is embedded in the second standard when the executive jet court said, if the function of the flight is serving a purpose traditionally performed by seagoing vessels. The further inland we go, for example, on a flight from Buffalo to Montauk that crashes in Long Island Sound, the aircraft is not performing a task traditionally performed by seagoing vessels. It's a mainland to another part of the country. It's more of a mainland flight. But what we're dealing with here is a coastal community where the aircraft was over land for seconds, going from Rhode Island down to the eastern edge of Long Island, totally a seagoing journey, if you will. And the other tempering limitation is does it have the potential to affect? And that's where we get into this, does this case have any qualities of maritime commerce? That I respectfully submit is not the inquiry for this court under Sisson v. Ruby, under Foremost, and under Grubhart. Those 3 cases that my colleague discussed very much went into the broad nature of the nexus issue as whether it has the potential to disrupt commerce. Because what we are doing here is we are deciding cases in the future. If we rule today that travel from Long Island, the eastern end of Long Island to Rhode Island, isn't maritime in nature at all, what happens when 2 airplanes collide in the Atlantic Ocean and disrupt the national shipping between New York Harbor and disrupt, and actually there is actual disruption.
That shows the nexus is satisfied.
And the way
I don't understand. It's a different factual scenario.
But the language from the Supreme Court is that the purpose of this maritime law and protection of commerce is so important that they are going to protect it even in cases where there is a potential risk.
With the potential, I know that's your argument. We understand it.
Yes.
Obviously, it's an interesting case. Thank you.
Thank you again for
All right,
allowing me to speak.
Thank you both. CC Realty Services versus Cavallo. Justice Scarpullo is recused from that case. Okay, we have just the respondent. 3 minutes. You can proceed, sir.
Good afternoon. May it please the court. My name is David Wolf. I represent the respondent, defendant in this appeal. The lower court correctly granted summary judgment to the defendant based on the express terms of the contract and based on the undisputed facts, which show that the closing was canceled and no commission was earned. Importantly, the closing was not adjourned for 2 years. It was...
Yeah, the amended brokerage agreement provided for the commission to be due on closing, right?
Yes, Your Honor.
And no closing occurred.
Correct.
On whatever contract existed for that 2015 closing date. Is that?
That's absolutely
your
correct,
claim?
Your Honor.
Yeah.
Yes. And when the defendant sold the property 2 years later, it was a brand-new deal, as evidenced by the plaintiff's own conduct and by the fact that there was a different broker involved who was paid his commission in full. There's no reason under these circumstances why the defendant should have to pay a second commission. Now, I know
Well, the first broker certainly did a lot that may have aided in bringing this about, but the question really becomes, once the brokerage contract is over, was that broker the procuring cause, right?
Well, so I don't believe that the procuring cause analysis really gets raised here because we have a contract which provides for the payment on closing only if the closing happened and is undisputed.
But the broker continued to do work after that relative to the parties who ultimately reached agreement on the buy and the sell here.
Right, and its work was unfortunately unsuccessful. It tried to get the buyer to increase its offer. The buyer didn't even respond. Now, the timing here is important because this occurred beginning in March and continuing through May of 2016, which is a full 2 years after the contract in issue between the seller and broker was signed. And the timing is important because the broker resurfaced in 2016, said, I have a new offer, which was the same $18 million that the buyer didn't accept. It then sent out a memo acknowledging that the February 2015 closing had been canceled, referring to the buyer as its client and saying that it would continue to try to generate new interest in the property, none of which makes any sense if the original contract was still in place, which is what the plaintiff claims. The buyers didn't want to deal with this broker. The broker didn't want us to know that, so they withheld the evidence of those communications.
Well, I don't know if that's true or not. It doesn't matter to us because it's not in our record. But I think we understand your arguments. But thank you.
So
no, you don't even have an adversary here.
So
we do have your briefs.
There were
no.
There were two new arguments raised. There were two new arguments raised in the reply. Thank you.
You could have used your time that way.
I was answering your questions, Your Honor. Thank you.
My questions are answered. Thank you. Okay, Style v. Sierra Custom House. Oh, my goodness. You can proceed, Counselor.
Good afternoon, Your Honors. May it please the Court, John Chun from Herrick Feinstein on behalf of the appellants. This case concerns a 2010 settlement agreement under which the parties effectuated a complete business divorce. Under the terms of that agreement, the appellants agreed to pay the decedent, Joseph Style, $100,000 per year in order for him to cease his interference with the companies and stay away from them. Mr. Style accepted that bargain and in return agreed to surrender his rights as a shareholder in the Sierra companies. He agreed to surrender his rights to any further payments or profits from the companies. He agreed not to be involved in any of the operations or the business of the companies. Yes, Your Honor.
That agreement, the settlement agreement, sections 2A and 2D, don't they make reference to Mr. Stiles as a shareholder?
They do, Your Honor, and those are precisely the rights that Mr. Style agreed to surrender in the terms of the settlement agreement. In fact, he agreed to forever forbear from bringing any rights or any claims in respect of the rights he surrendered under the settlement agreement. And it wasn't only his rights that he surrendered, Your Honor. Under Section 10D of the settlement agreement, he also agreed to surrender the rights of any future transferees of the shares, including the plaintiff.
You would allow that he still is entitled to sue under the settlement agreement.
That's correct, Your Honor. The release that was attached to the settlement agreement did not bar him from bringing a suit in respect of breaches of the settlement agreement, but no such breach is alleged, Your Honor. In fact, over the next 10 years, the Sierra defendants fully complied with their agreements and paid him and his family over $1 million. And in return, what Mr. Style promised on behalf of his heirs, himself and his heirs, is that the shareholder rights would be surrendered. When Mr. Style passed in 2020, his shares were transferred to the estate, and that estate is now currently represented by his personal representative, his widow, Ms. Style.
Right.
Under black-letter law handed down from the Court of Appeals for over a century, the law is that a personal representative stands in the shoes of the decedent and is bound by the contractual commitments of the decedent. Your Honor, the principles of res judicata stand for the exact same thing. Let us not forget, this was a court-ordered settlement agreement that was so ordered by Justice Lowe to put an end to litigation that had been going on for years between Mr. Stile and his sons and the C. Heir defendants. The allegations that Ms. Stile is making in this case, that the res judicata doesn't apply because the issues weren't decided, is simply incorrect. If Your Honors look at the complaint that was filed, that this settlement resolved was a litigation between the C. Heir defendants and the Stile and his children because they had misappropriated the information of the C. Heir companies. They were interfering with companies, soliciting their employees, and this settlement agreement was meant to put an end to that, to separate the C. Heir defendants from Stile and his families. And Your Honor, even if you were to put those doctrines aside and ignore the black-letter law about personal representatives standing in the shoes, if you were to ignore the law on res judicata and focus on the settlement agreement itself, the settlement agreement provides that all transferees of the shares are bound to the exact same surrender provisions.
So, counsel, but it doesn't provide that he's not a shareholder anymore, right?
That's correct, Your Honor.
So to the extent that she alleges that you are trying to say that she is not, or the estate is not a shareholder, that's not prevented by the settlement agreement.
Well, Your Honor, let me be precise about that. What the settlement agreement says is for her to take the shares as a transferee, she has to acknowledge in writing to be bound by the
Okay, I'm not, we're
never provided
talking about your motion to dismiss her claim that you refuse to treat her as a shareholder. Now, that claim is not barred by the settlement agreement and I'm agreeing with you. She has to sign a piece of paper at some point that says, you're bound by this settlement agreement. But that doesn't, we don't have to decide that now. Maybe have you offered her the piece of paper? Have you, in your answer, do you say, we offered her the piece of paper and she didn't, that she won't sign?
Your Honor, if she will hand her a piece of paper today. She has not complied with the settlement agreement at all in that regard.
Some of her claim is that. That's all I'm saying.
Your Honor, if I respectfully may, I respectfully disagree with that. All of her claims arise out of rights that were surrendered in the settlement agreement.
Let me just read you. The second cause of action alleges that they're guilty of shareholder oppression because they refuse to recognize her as a shareholder. That's the claim, right? And we can both agree, at least to that extent, that's not barred by the settlement agreement.
Your Honor, what she's asserting there is that we refuse to recognize her rights as a shareholder to inspect the books and records because that had been surrendered under the terms of the settlement agreement, Your Honor. And in respect of all of the rights she actually is asserting, a right to payment and profits, a right to dividends, a right to the dissolution, those were all waived in Section 10B of the settlement agreement itself.
Okay, we understand your arguments. Let's hear from your adversary.
Thank you, Your Honor.
Thank you.
May it please the court, Harlan Lazarus for the State Representative Claire Stile.
So what do you make of this, the black letter law that the estate representative stands in the shoes of the decedent?
Okay.
Right? We acknowledge that.
We acknowledge that. We acknowledge that.
So we have a settlement agreement.
Right.
Right? Why isn't the personal representative bound by the terms of that settlement agreement?
Because the decedent, her husband, never gave up his rights as a shareholder. There's no document.
Whether he gave up his rights as a shareholder, whatever that means, he did expressly give up certain rights in the agreement. It's
Agreed,
express.
Your Honor.
It seems pretty unequivocal, and she is asking for rights that seem contrary to what's provided in the settlement agreement.
Your Honor, throughout the settlement agreement, the cutoff of Mr. Stiles' rights is conditioned upon the payment of monies. He is entitled to the payment of monies, right? And what would happen here, theoretically, I suppose, is we become a shareholder but get no money because the right to the compensation ceases upon the death of Mr. Stile. There is nothing in the settlement agreement that addresses this particular circumstance. In fact, Your Honor, counsel.
You asked for more than that. You asked for more than just the payment of monies that are due under the agreement, which your adversary is just, he's acknowledged to me that you can sue under the agreement. You can sue for what's due under the agreement. But you asked for things like, let's take some basic stuff, like the production of the books and records in your capacity as a shareholder. That, in fact, was expressly waived. You may, if you start a lawsuit, you may have the right to discovery if anything otherwise survives. But I just don't understand. Some of these causes of action seem so contrary to what was expressly waived in the settlement agreement.
Your Honors, the right to, or the waiver of the rights to inspection is expressly conditioned on Stile agreeing that so long as the payments and benefits are provided, he waives it. That's a condition. He is, unfortunately, of course, he's deceased. They're not paying him, and therefore the waiver is no longer in effect.
So wouldn't it make sense that you own the shares and you can sell them back, but you can't do anything that he, in the settlement agreement, agreed not to do? That makes total sense, right? That gives effect to everything that's going on here.
Your Honor, were that the end net result, that we be bought out of it on the value of our shares, I don't think that that would be objectionable.
Is there anything preventing you from selling your shares to somebody else?
Yes, they say we're not a shareholder.
Well, okay. So
that's a problem. So, and I want to just refer briefly, Your Honors, to the state court complaint that gave rise to this, because it's interesting. That state court complaint does not ask for any relief as to Mr. Stile's shareholder interest. They never mention anything about his not being entitled to those shares. What they do mention is the concept of Mr. Stile not being entitled to involve himself with the corporation anymore. Now, that's exactly what they got in the settlement agreement. They got Mr. Stile not to involve himself in the operations of the corporation. They didn't get Mr. Stile to give up his shares. We have sophisticated counsel here drafting an agreement that provides for the rights of shareholders. They have 18 or so recitations of all of the things he cannot do as a shareholder, and yet, Your Honors, they don't provide that he doesn't have his shares anymore. That's absurd. It's absurd to suggest, as the defendants do, that Mr. Stile willingly or knowingly or even conceivably gave up his rights as a shareholder, which is the position that is taken by the defendants in this lawsuit. If the defendants want to continue the stream of payments to the estate, I suppose that would be an equitable solution.
Right,
but they can't have their cake and eat it too.
I think we understand what your argument is.
Thank you.
That the things that survive that he can sue on. Okay.
Correct.
Okay. Rebuttal?
Thank you, Your Honor. I'll be quick.
Shouldn't they have a right, shouldn't the estate representative have a right to sue under the agreement for the rights that survive?
Absolutely, Your Honor. That's preserved in the settlement agreement itself. If we breach the settlement agreement, they can bring claims, but none of the claims they're asserting have anything to do with any breaches. In fact, they don't dispute. We paid them over $1 million over 10 years.
Yeah,
they're perfectly happy with
maybe
this.
Maybe you owed them $2 million.
Well, Your Honor, they can assert that claim. They haven't in this case.
Let me finish. You can't talk over me.
All right, Your Honor.
So that the amount that you pay them in the past is somewhat irrelevant. The question is, looking at this agreement, is what is preserved? What did he give up? what did he retain, and whether this has been complied with. And that's what we need to parse out on this appeal.
And correct, Your Honor, if I could give Your Honors a shorthand, he gave up all of his rights as a shareholder. He gave up his rights to payments or profits. He gave up his rights to be involved in the business operations. There's a laundry list of other things under
Except,
Section
counsel,
10.
can we agree that he didn't give up the value of his shares, whatever it is, correct? And so when plaintiff says to me that you have taken the position that the estate doesn't own the shares, they may be less valuable because he's given up all these other rights. But is it your position that no one owns the shares?
No, Your Honor, that's an
Well,
absolute,
you're
that's an
saying they
absolute
do own the
misconstruction.
shares.
That's an absolute, yes, Your
And
Honor, but what
so-
our argument is, they have no standing to bring these claims because, as we talked about earlier, they've got to submit a writing as a precondition of the transfer.
Whoa, wait. The agreement says that the shares were not transferred, and quite frankly, he's been getting K-1s or his estate, where they've been paying taxes as a shareholder. So I think that there's at least something to figure out here.
Your Honor, the K-1s ended for the tax year 2019 when he passed away. Because he has not submitted the required writing under the transfer provisions, agreeing to be bound by the surrender provisions as a precondition of a transfer, he's, in that respect, they don't have
Parsed out in
standing.
the underlying litigation, I think. But we'll see. We understand your position.
Thank you, Your Honor.
Thank you both. Okay. Seymour versus Hovnanian. Right. You think the officer's going to try and start to organize you, right? We're going to, yeah. We'll start with the two appellants, and then the respondents. Since all the respondents have 2 minutes, I'll let you organize yourself. And you'll identify yourself as you come up. Sorry. Okay. Okay. Appellate Hovnanian.
Good afternoon. May it please the court. My name is Daniel Kotler from Lester Schwab, Cass and Dwyer, on behalf of defendants, appellants, the Hovnanians. Jumping right into the attorney's fees issue, there's nothing in this clause, in this indemnity provision, that clearly and plainly applies to
Well, you would allow, it's a broad provision, is it not? I mean, just generally, it's broad. It's not limited. It doesn't say it only, the words only don't appear. I know you don't want to concede that. Okay.
I don't want to concede that.
All right, then we'll go about this another way. Right. It's okay.
I don't want to concede that specifically because it has a specific, broad is a difficult term to define, but it has specific subclauses, Roman numeral 1, Roman numeral 2. It has, through Roman numeral 4, it specifically enumerates what it applies to. So in that regard, it's not
correct, but at some point, like with respect to Roman numeral 2, it says that the license agreement requires defendants to indemnify plaintiffs' decedents for any loss of expense, including reasonable attorney's fees, include by plaintiff's decedents as a result of, quote, the execution and or existence and or the effectuation of this agreement, including. So the reason that I'm emphasizing that including, because it's not limited to, it says including, which means it's broader than the clause that comes beyond it. Claims for personal injury or property damage sustained by any contractor, worker, or any other third or non-party, close quote. So it clearly includes third-party claims, right? Right.
Well, it includes,
including.
It includes third-party claims. It includes personal injury.
It includes the third-party claims as identified here, correct?
It includes the third party, yes, Your Honor, it
Okay.
includes,
And because it says including, that means that the general clause that came before it is broader, does it not? As a matter of just construction, does it not?
in this case, no, because the language of
So then what does that mean? What does the language before that, what other than the including language does this apply to, or can it possibly apply to? It's got to be more than the including clause. You're saying it's not the intra-party clauses, so what else? What else could it apply to?
The including is referring to claims for personal injury or property damage. Those are claims that are specifically limited to, in the next part of that sentence, sustained by any contractor, worker, or any third or non-party. It's not a whole bunch of stuff, including but not limited to third or non-party claims. It's saying a variety of things, including personal injury or property damage claims, but only
what
such.
else? So you're not answering my question, which is, that's right, that says including, and it does say, and it doesn't limit it. So now it clearly applies to more than that. What else does it apply to? Tell me under your construction, so that I can understand it.
Including claims for personal injury or property damage to the third or non-parties. Other claims could be, it could apply, property damage and personal injury is broad, but it could apply to a claim for a liability to the city for a code violation, liability, a claim for a trespass claim. There are a variety of claims that non-parties to this contract can bring that wouldn't specifically be personal injury or property damage claims. The key point is that property damage claims are limited to third party, to non-parties to the contract. Plaintiffs in this case clearly are parties to this contract and therefore are excluded from this term.
Not expressly excluded. That's the
Not
problem
expressly
here,
excluded,
right.
but they're not included. They're not plainly
They're not expressly included.
Right. And I would point that there are, I would emphasize, as I did in my papers, that there are other provisions of this license agreement that do address intra-party disputes. That those are specifically turning back to 9K deals with in the event of any damage to adjacent owner's property resulting from any aspect. I believe it's 9J, turning back to the previous page, that refers to a breach of the contract not in full conformance with the requirements. So if we read those sorts of claims, if we read plaintiffs' claims in this action into Section 11, then we're rendering 9J and 9K meaningless, which is contrary to the rules of construction.
Okay,
Seeing my
thank
time
you.
is up, I'll
Right, we have
my
your
briefs.
paper. Obviously, there's so many parties here. It's a complex case. We're aware. We have your briefs, and we're familiar with them. We're not going to decide it just on 2 minutes of oral argument. Don't worry about that, okay?
Thank you, Your Honor.
Right. All right, let's have the Seymour appellants.
Good afternoon, Your Honors. My name is Brian Wattoon. I represent the Seymours in this matter. This case is about Mike and Katrina Seymour, who lived in their home for 56 years.
Yeah, we're pretty familiar with the facts, and because we do have limited time, it's only a suggestion, but I would go right to the heart of the matter if I were you.
I'll start where you left off with
Okay.
my colleague.
Thank you.
As to the attorney fees, Your Honor, there's no, it's impossible almost to draft a broader indemnification provision than this. This provision is broader than the provision in Shaw, which is cited in the briefs, and also uses the incurred by language that defendants dispute in this situation. It's broader than GLCA securities, in which this court also held that the indemnification provision provided for attorney fees. And as Your Honors
Well, it
point
clearly
out,
provides for attorney's fees. The real specific issue here is whether it provides for intra-party claims, right? Isn't that what we're talking about?
Yes, it is,
Yeah,
Your
we
Honor.
know-
And
we agree, it says attorney's fees.
Right.
But it doesn't expressly say intra-party claims.
I
Right.
was just referring to attorney fees as a shorthand for attorney fees in intra-party claims and costs. The contract refers to indemnification for the execution, existence, and effectuation of the agreement. It provides for coverage.
Isn't that in a different, I'm sorry, I thought that was I thought that was in a different provision, no?
It's on page 205 in paragraph 11 of the license agreement.
That would be in subsection 3 of that
Exactly, Your
agreement?
Honor. Yep. If you look at subsection 2, any claim brought as a result of the actions of project owner or its agents as set forth in this agreement or any work performed upon the adjacent premises. It would make no sense for the word including to be modifying claims when you've said any claims at least 3 or 4 times previously in the paragraph at that point. Furthermore,
No, as I question your adversary, once you put in including, then the language that comes before it clearly has to be interpreted broader than what it's including.
Exactly. Yep. And it's impossible to, if that language were interpreting the type of claim as my adversary has suggested, it would be impossible to broaden because the contract already referred to any claim, any and all claims.
Counsel, can I ask you, what damages are you seeking for loss of habitability? What are you claiming are your damages on that claim?
The costs of moving, the replacement living costs, transaction sort of costs from the move, from seeking the alternative living arrangements, from the emergency forced evacuation from the toxic dust in 2013.
So wait a second, so you're not conceding that you incurred no cost from vacating the premises? You're saying you did incur costs from having to vacate the premises, is that correct?
Yes.
Okay.
What is the liquidated damages for? What is that supposed to compensate for?
The liquidated damages contemplates, and of course there may be some overlap, and to the extent that there is, that can be determined at the damages stage as to what's duplicative. But the loss of habitability was a years-long claim, and
well, what are the liquidated damages supposed to compensate you for?
The extended and protracted nature of the construction project. And
well, isn't that part of your loss of habitability claim?
Loss of habitability was primarily tied to the toxic dust, the lead dust.
Wasn't that paid for by insurance?
It should have been, Your Honor. It should have, but that's something that's still being.
Was there anything left over that wasn't paid for by insurance?
Yes, yes. We're even today. That's why we're still here. We've had trouble getting anything out of the clear terms of this agreement to which defendants obligated themselves, and which
I guess
benefited.
what I don't understand, right, and it's the damages. You have a liquidated damages clause, and again, I'm going to ask you, what was that meant to compensate for, and why is it different than the compensatory damages that you're otherwise seeking under the contract? What's different?
First of all, and most obviously, the time frame. The liquidated damages provision was a 10.5-month accrual, whereas this case and the damages and the other claims encompass far broader time periods. Secondly, the liquidated damages provision was meant to encompass not just loss of habitability, but also interference with the Seymour's ability to live in their house and peaceably enjoy it.
I'm sorry, maybe I'm reading this wrong. I know in the termination section, correct me if I'm wrong, but there was an obligation on the part of the defendants to get a temporary certificate of occupancy within 18 months from the date of this agreement, which was May 2nd, 2013.
Correct.
And if they failed to do so, then they would be charged $1,000 a day until they got that TCO.
That's right, Your Honor.
Okay. Now, that TCO is referable to their property, not your client's property.
Correct.
You didn't need the TCO for your client to move back into your property, arguendo.
Yeah, the TCO doesn't affect
That's my
habitability
point.
of.
So to the extent that the dust and the vibrations and all the other private nuisance and all that other stuff, you have the ability to get compensation for it under this license agreement. The $1,000 a day can be viewed, arguendo, as a penalty if you don't get that TCO, because we don't want this to schlep, beyond 18 months. You're going to be charged $1,000 a day. It's not designed to compensate you because the licensing agreement does exactly that. And for any loss of habitability referable to dust or anything that insurance doesn't cover, I guess, you'll be able to be here in this case and get compensation based on your proving the damages. So again, forgive me for reiterating the question my learned colleagues have asked you. What exactly is the $1,000 a day designed to do other than to punish for not getting that TCO on time?
I see that my time is up. May I answer?
Please.
You may.
Oh, I'm sorry.
So,
I agree with you. We agree on that.
well, I completely disagree, Your Honor. So the TCO, while applicable to defendant's property, not plaintiff's property, is a proxy and was used as a proxy for when the most significant construction would be done on defendant's property, and thereby the most significant burdens on plaintiffs who got nothing from this project would also be over. And it's no reason to invalidate a valid liquidated damages provision that defendants negotiated through counsel and specifically got the terms that they wanted, to say that other parts of the license agreement might also apply for, might also provide for damages, especially because one of the reasons for liquidated damages provisions is when damages will be difficult to estimate after the fact. So,
Figure out what the damages were for. We could figure out if they were hard to calculate.
well,
Because right now, it just sounds, and you even admitted in oral argument that they seem to overlap the loss of habitability, at least in part.
Yeah,
And I have to say, we are a little bit sobered by the Court of Appeals look at liquidated damages clause these days, and we're sobered by it. Let's put it that way.
Well, I think the Court of Appeals has been clear that liquidated damages provisions are generally enforced, especially when negotiated through counsel, and specifically the terms are requested by the party seeking to avoid them. And as to the
Are you telling me that the liquidated damages was requested by defendants in this case?
the terms, Your Honor, the original.
It was negotiated, right?
Exactly, and it was limited in the way that that defendants requested. Then,
Why, there was an unequal bargaining power here? I'm not honestly following. But
Your Honor, I'm
it's
saying
okay.
that defendants should be held to the terms that they negotiated and the terms that they limited.
I understand that, and we're just asking you questions because now they're questioning it, and we have some Court of Appeals authority, and maybe we need to look at it, maybe we don't. But
If I could just finish just circle back very
No.
briefly. Okay.
Thank you. Again, we have your briefs, and we know this case. I think we know all the cases, right? Okay, let's start with the respondents. In the order that you choose, you'll have to identify yourselves to us.
So I am a third-party defendant. May it please the court. My name is Puichi Chang with the Law Office of Chang & Associates, and I represent the third-party defendant, ADS Construction Corp., DBA Auten Contractors.
Thank
The lower court properly denied Hovnanian's motion for indemnification and contribution against Auten, which this court should affirm. And the three reasons that this court should affirm the lower court's decisions are: one, Auten was a construction manager and not a general contractor. As a construction manager pursuant to a contract, Auten had no control over the means and method and did not direct the work that was actually being done in this gut reno of the townhouse. Auten's responsibilities basically were limited to scheduling, selecting finishes, doing invoices, and such. And then the second reason is that Auten, as I mentioned before, did not do any of the construction work. So any work which may or may not have resulted in any damages was not done by Auten. And this is not disputed by Hovnanian. And the third is that Auten was not a party to the license agreement. So Auten isn't responsible for any of the terms and any of the damages or penalties that are set forth in the license agreement. And therefore—
That wouldn't apply to the torts, though, right? That argument only applies to the contractual claims.
Correct, Your Honor. Okay. But in this instance, because Auten didn't do any of the work, it didn't do anything tortious.
Well, that's an overall claim that goes to all of the claims for contribution and common law indemnification. But the fact that they weren't a party to the contract is only to the contractual causes of action, right?
Correct, Your Honor. There would be the common law. And with respect to common law, without the negligence on the part of the party, then therefore under common law, it would not be owing any indemnification either. And if there are no other questions, I will take my seat. Thank you.
Thank you. You may proceed.
Good afternoon. May it please the court, my name is Gino Wischusen. I represent a third-party defendant, respondent, Signature Interior Demolition. And I know the court is very familiar with this matter. So very briefly, Signature would submit that the trial court properly dismissed the Hovnanians' claim for contribution based on the economic loss rule, and also the claims for common law in, the claim for contribution, I apologize, and the claim for common law indemnification as to Signature, as the Hovnanians did not establish that they were free from negligence, while Signature claims that they also were free from negligence. The expert affidavit of the engineer provided by the Hovnanians was conclusory and speculative, as the trial court found. And
Excuse me, counsel.
yes, yes, Your Honor.
Signature withdrew their appeal?
Yes, Your Honor.
Okay. And correct me if I'm wrong, but one can have a claim for contribution with respect to property damage as well as personal injury, correct?
Yes, Your Honor.
So there can be a basis for contribution for property damage, so the economic loss rule does not necessarily make someone off the hook. Do you agree?
We, as we indicated in our papers, believed when the trial court applied the economic loss doctrine in dismissing the contribution claim of the Hovnanians, that it was correctly decided and that that decision should be affirmed. And given that the Hovnanians have not established that they were free from fault, separate and apart from anything Signature may or may not have done at the premises, that the trial court's decision should be affirmed.
Thank you.
Thank you.
All right.
Good afternoon, Your Honor. May it please the court, my name is Siobhan Healy, and my law firm represents a third-party defendant, respondent Gil Sans Marine Stefik. My client installed the vibration monitors for the project, to give some context. And to speak directly to the question that Your Honor raised regarding injury to property, Again, most of us third-party defendants have the same issue, so I'll be brief, but it is that injury to property, while contemplated as a basis for contribution under the CPLR, under the prevailing law of Sergeant Webster and its progeny, the courts have held that economic loss only arising from breach of contract does not constitute injury to property within the meaning of the CPLR.
So,
I'm sorry.
Go ahead.
Yeah, it's the same
I just want
question.
to, I want to ask you, if you're found liable for private nuisance, that's a tort, right?
That
So
would
if
be a
you
tort, Your
put
Honor.
the- you
However,
put you wrongfully put something on the other party's property that you weren't supposed to, that's a tort, that's an injury to property, and that would be a proper basis for contribution, right?
while the cause of action in itself could give rise here, what the court did properly is look at the remedies that were sought. And even under the First Department law, they say the touchstone really speaks to what are the damages sought.
What other damages would you sue for a private nuisance?
I'm sorry?
What other damages what would you sue for a private nuisance? The fact that you pay money for the private nuisance doesn't change the fact that it's a tort rather than a breach of contract, which would make those economic losses that are happen because of a breach of contract aren't subject to contribution. That would make it, those aren't applicable where you have a tort that results in injury to property. I'm sorry, I'm going to get this out.
It's okay, it's getting late.
Results
I
in
understand.
injury to property that can be compensated, right?
Well, nuisance is a
Isn't
tort.
that what the plaintiff is alleging here?
What the plaintiff is alleging is we entered a license agreement, and while they spin off various causes of action from that license agreement, the remedy they're seeking is to be placed in the position they were had the license agreement been complied with. So I think what the court did properly here was look at the overall damages. What is the thrust of this case? What is the gravamen of the complaint? And that
But
damage is sought.
when the statute says injury to property can result in a contribution, what is it say anything about? But if you also have a breach of contract claim, I don't think so. When I'm looking at the statute, that's exactly, I have an injury to my property because you did a tort, and I want you to pay for it, right? The measure of damages might be referable to a contract, but it's not excluded because this isn't a contractual claim.
I disagree. I think this is very much a contractual claim, and
Okay, but
that
did
is
they
what the
not
court
sue
saw below.
I'm sorry, I didn't mean to interrupt.
No,
you.
that's
Did they not sue for nuisance and trespass and all those other things?
They did, but what the court indicated below, and what I think is proper here, is that's not the gravamen of the complaint. I would also add, as to specific for nuisance, when you talk about things that happen to their properties, as specifically to my client, those would not be able to be passed on through contribution because my client only placed vibration monitors next door. So while, the principle, may change depending on what causes of action remain below, how they apply will depend on the role of each party in the construction. Thank you, Your Honor.
Thank you. All right, next.
Afternoon, Your Honors. Paul Agatuda for JG Construction. I just briefly want to point out that the damages alleged in this case supposedly started many months before my clients even appeared on this job site and continued for many months beyond the time frame that my client was on this job site. The dismissal of the claims of negligence as against my client and the affidavit and testimony by Pelori and Pelori's expert that the monitors, the vibration monitors, registered at 0 during my client's scope of work, I believe conclusively establishes that my client's work did not cause any damage to this property that was owned by the Seymour family. And respectfully, I request that a search of the record be made and dismiss all claims as against my client because...
Let me ask you this.
Yes, Your Honor.
Is it clear who put the splice box onto the other property?
I have no involvement with it. We had a very
Is that clear? And what about all the other stuff that was, the ducts and the vents?
that goes well beyond the scope of the work that my client was involved in. My client was the underpinning work.
And everyone agrees that you
Yes.
had nothing to do with the splice box or the ducts and the vents?
Absolutely, Your Honor. The record before this court has Mr. Pelori testified as the principal of Pelori Associates that the work, in fact, was performed as spec'd, scoped, and the monitors, the vibration monitors, never registered any vibrations that could have, in fact, caused any damages.
But you're arguing here that we should search the record because procedurally you didn't ask for this.
On my papers, I moved for an outright dismissal, and then upon review of the lower court's decision, dismissing the negligence claims and the breach of contract claims and all the claims, as well as the common law indemnity
You
claims.
moved below.
The lower court.
Right.
I'm
Yeah,
sorry.
right. We're agreed, but you didn't appeal.
No, I didn't. I'm
Right.
just saying a search of the record, Your Honor, respectfully. Thank you very much for your time. Nice to see you guys again.
Thank you.
Thank you.
Okay.
Good afternoon, Your Honor. My name is Vincent Camacho. I represent O'Neill Architect. I may please the court, but I would like to actually draw your attention back to the contribution argument, which is the main basis of our response papers.
Right.
And the argument that the damages are sought are contractual. And I would like to draw your attention to the license agreement on page 202. And it's paragraph 9F. And it basically, says, project owner shall promptly repair and damage any damage caused to the adjacent premises, including, and then it goes on to list a number of things. The license agreement laid out that the damages that the plaintiffs would be entitled to are within that agreement, which is the basis of Sergeant Webster and the progeny of cases that come after it, that it really goes into what the damages are. And the license agreement lays out the remedies that the plaintiffs have to seek out damages for any of the damage that was caused, including private nuisance and things of that nature at the project. That's the whole point of the license agreement. My client wasn't a party to the license agreement, but as far as a contribution claim is concerned, it's not the lower court properly dismissed that claim because all of the damages.
So, counsel, you're saying that the plaintiff couldn't have sued you directly for the nuisance and all the other tort claims?
No, Your Honor.
Could the plaintiff have sued you directly for a tort claim saying you improperly wrecked my property?
I mean, as under the facts of this case, I would say that no, because my client.
So if you're the person who put the Verizon splice box, or you're the person, I don't know if you are or aren't, because it wasn't clear to me who did all this stuff, the ducts or this or that, the plaintiff couldn't have sued you directly?
Well, I would argue under the.
I mean, there's a tort claim against you, right?
Under the facts of this case, the plaintiff cannot have a tort claim against my client because my client didn't perform any of that work.
So you're saying that the plaintiff didn't fail to state a tort claim against you. Is that your argument?
No, well, my argument is that my argument falls back onto the fact that the causes of action against the Hovnanians is for breach of contract, and thus Hovnanians can't sustain a claim for contribution based on the facts in this case.
Okay. Thank you.
May it please the court, James O'Brien on behalf of Pelori Associates. Your Honor, Pelori Associates was the geotechnical engineer for this project. Our arguments with respect to the properness of dismissing the contribution claim are the same as the architects, essentially, and of GMS. Your Honor was asking about the nuisance and the trespass claim. They're based upon the installation of mechanical vents and the placement of a Verizon box on the outside of the plaintiff's property. As a geotechnical engineer, Pelori would have nothing whatsoever to do with these two things. So the claim trespass, the claim nuisance has nothing to do with Pelori. The only claims that are made against Hovnanian, which they're basing their contribution claim are the breach of contract, which is the license agreement.
So let me just try and articulate what I've been hearing now from you and your fellow attorneys. It's essentially your position that the main defendant, the adjoining property owner, the Hovnanians, have wrongfully sued you in third-party practice for contribution, A, because you had nothing to do with all of the claims that are being raised here, and B, because you were not party to license agreement, which bind the Hovnanian to be able to make whole the plaintiff for all the damages that flow from the project. Is that essentially your position?
That's correct, and because the claim is essentially a breach of contract, and Judge Crane agreed that there was no basis, no legal basis to bring that claim against Pelori or the other third-party defendants. So, unless there's any other questions, we'll rely upon our brief.
Thank you. Okay, I think our last respondent, go ahead.
Good afternoon. My name is Louise Cherkis. I represent Mitchell Iron Works. Mitchell Iron Works had a limited role, and like all the other third-party defendants, it was proper for the lower court to dismiss the contribution and the common law indemnification claims. We were retain a very limited contract. We fabricated off-site certain metal, and when there was installation with handheld tools, there was no indication of vibrations during the time we did our work. We did our work. Things had started before we started our work, and we started sometime in 2013, not 2012, when the complaints were going on back then. On an interesting point on the common law indemnification is the Hovnanians' papers in the court below were, besides for us all talking about this as core breach of contract, they really did not even talk about common law indemnification in their papers in the court below, and the court, therefore, making the determination to dismiss it, that was another factor that the court was able to consider as well. As far as us as well, the Hovnanians' papers, when they had an expert, their expert didn't even address our own deponent's testimony, where he stated that, how we performed our work, and didn't address our contract, and so for that and so the court obviously rightly, found a lack of merit there. I know you have my papers, and there's so many others that if you don't have any other questions, I will rest on my papers. Thank you.
Thank you. All right, Hovnanian, you have rebuttal. Yeah.
May it please the court, plaintiff said that the indemnity provision in this case is broader than that.
I honestly, you only have a few minutes. I would actually prefer if you answered the myriad of respondents' arguments about contribution and common law indemnity with the time that you had.
Okay, I can focus on those issues. In terms of the contribution issue first, absolutely there is, plaintiff's claims are not limited to the contract. Plaintiff sued on a variety of tort claims, And the fact that there are some contract claims doesn't mean that there could not be liability under those tort claims or that those.
So, counsel, are you taking the position that every one of the third-party defendants is potentially liable on every single one of your tort claims?
I would answer that the word potentially is important in that question and
Okay,
in my
so
response.
have you alleged in your complaint that every single one of the third-party defendants will be held liable, should be held liable on all of your tort claims?
On some, yes, on some level, in some ways,
Well,
on
what does
different
that
aspects
mean?
of the
Can you be specific? Like, pick one of the third parties who said, we had nothing to do with any of the tort claims. We did something else. Pick any one of the third-party defendants who said that.
I will concede that at this juncture, I can't answer with specificity because it's a very long project in which each individual defendant did different, third-party defendant, each individual contractor did different aspects of the work and can be responsible for their aspects of the work. So the fact that they're not responsible, they didn't work during.
Well, let's be more specific. Is the trespass claim based on the splice box?
The trespass claim appears to be based on the Verizon work, which, as
Okay, so which of the respondents here was involved in work regarding the placement of the splice box?
specifically,
Or could have been?
specifically in regarding the splice box, my understanding is that was Verizon. So that's the answer on that.
And Verizon is not one of the respondents?
That is correct. There are other trespass issues in this case, however, involving workers using the scaffolding that was supposedly they weren't supposed to step onto, and other issues along those lines. So the splice box is Verizon, but that's not the limit of the trespass arguments.
Honestly, well, do you want to hear about the common law? Well, all right. I want to ask about liquidated damages. So I know your light is on, but I'm going to pursue it anyway. All right. On the liquidated damages clause, it's true. Your client negotiated that, right? I mean, it was part of the license agreement, right?
Yes, Your Honor.
Okay. And it says by terms, it says that if you don't get the temporary C of O for your property, that within 18 months, that after that, there will be $1,000 a day that is paid as liquidated damages, right?
Yes, Your Honor.
That's what it says. All right, so to what extent, if any, does the fact that there was no fee paid for this license to the Seymours affect whether that is, as we have previously inquired of your adversary, whether it was a penalty or otherwise an indication of a damage for a compensatory damage that otherwise couldn't be calculated?
There are several parts of my answer to that question. The first part is I don't have the section of the license agreement tabbed, but in my briefs I call out there is language saying that there was consideration. Beyond that, the fact that an agreement is negotiated by parties doesn't mean that, as a matter of law, it's enforceable. There's all manner of situations, including liquidated damages provisions, where the parties agree to something and then they realize after the fact, for whatever reason, actually, as a matter of law, you're not allowed to agree to that. It doesn't matter how sophisticated you are. It doesn't matter how many lawyers you have. This is not an enforceable agreement.
What are you're basing it, in the Court of Appeals decision, the name of which escapes me now, but the court said either it's unconscionable or the damages to which it's otherwise referable would not approximate or would come close to what the liquidated damages are. So let me ask you, I'm going to ask what I asked your adversary. What was the liquidated damages clause for? What was it for?
It appears to be designed to compensate them for the plaintiffs, the Seymours, for the inconvenience of having construction on the adjacent property. Presumably noise, people going back and forth, debris, what have you. Construction on a party wall, the typical things. However, we have a value from plaintiffs not only from the rent they charge the upstairs tenants, but also from their own appraiser for their apartment as to the value of the complete loss of their apartment. And the complete, not just inconvenience, but the complete loss, the liquidated damages provision is 5 times that amount. So while you can argue, all right, you're some premium for inconvenience, it's the home you've lived in for a long time, it's a lot of, you have to move out, although they were already moved out when this came into effect, 5 times is or the complete loss is enormously disproportionate. And as I
So the fact, I'm just getting back to my original question, the fact that under the agreement, they were not you were not required to pay any fee to them for the license bears no relation to the liquidated damages, or
it's
does
not, liquidated damages aren't meant to replace a fee. If they wanted a specific fee negotiated, that would be a different term. That's not the same as liquidated damages.
I'm just curious. I know the agreement provides that this license agreement has been based on consideration. What's the consideration that it refers to in it? You mentioned that there was consideration. What was it?
The answer honestly is that I only know what the license agreement says. So I can't answer the question, unfortunately. And I suppose since I see my time is up, I would say, just in conclusion on liquidated damages, as your honors seem to be leaning towards, if this liquidated damages provision is enforceable, it doesn't make any sense to also go on and say, oh, well, let's have a trial and find out what the damages are. Either they're liquidated or they're not. So, your honors have my briefs. Thank you for your time.
Thank you, thank you. All right, let's hear from the Seymours. Well, go. Last 2 minutes.
Mr. Morris.
No, the
Seymours.
Seymours, right? You're the last one in this.
Yes, thank you, Your Honor. And to circle back on where we spent most of our time on the liquidated damages, well, to answer your question about what was the consideration, well, the Seymours derived no benefit at all from defendant's project. The consideration that they received for the license agreement were the very obligations, including the liquidated damages provision, that the defendants undertook in the license agreement.
How do you reconcile the terms of the license agreement with the Court of Appeals case in D'Agostino? Where such an agreement would be unenforceable?
Well, I believe it's on defendants to the party seeking to avoid the liquidated damages provision to demonstrate that it's grossly disproportionate, not just disproportionate, but grossly disproportionate. And all
Well, they're saying that it's 5 times the amount that you would be entitled to based upon the rental agreement, the rent of the upstairs and also their apartment.
Right, that's defendant's argument, and this gets back to what we were discussing before in terms of the overlap, but not exclusive coexistence of loss of habitability and liquidated damages, in that, of course, there's a dollars and cents, calculable amount in terms of, it cost me this much to move, it cost me this much to pay for the assisted living facility that we had to leave our lifelong home to live in. Defendants have also talked about just the, kind of replacement rent, as though, the Seymours were disinterested landlords of their home. But beyond that, liquidated damages was meant to approximate the interference with, the home of people who had lived there for 56 years that couldn't be readily calculated in that dollars and cents amount. And, that's the purpose of liquidated damages, is to compensate based on a prospective estimate of what these kind of inestimable losses are going to be. And it's somewhat, it's just simply incorrect to place the value and limit the value of what those damages were to the simple cost of, well, if we had rented out the Seymour's apartment on the day that they were forced to move out, what could they have gotten in daily rent? That's not even an accurate, purely economic estimation of the Seymour's damages, and it's not a good estimation whatsoever, let alone one that satisfies defendant's burden to prove gross disproportion once you factor in the inestimable loss of the Seymours leaving and being forced to leave their lifelong
Well,
home
let
in
me
the
just,
final years of
just
their life.
ask you this, isn't that the way we always estimate loss of habitability? I mean, that's what we do. That's the way we figure out how that contract, how if I don't get the benefit of my contract, and my contract is I get to live at my place, that's always how we estimate those damages, right?
Yeah, and that's
So why is that weird or different here?
for the reasons I just outlined, Your Honor. Liquidated damages is broader than the loss of habitability, both in terms of time, as I discussed, and
But
just
it's
now.
supposed to compensate you for what you would have lost under the contract, right? And generally, what we do when someone loses the ability to live in their place is to estimate those damages by who else, you know, I had to go somewhere else, and so here's the number. That's a very common way to do it, right? So you're saying you want to add in more damages, which are the cost of moving and all the other things. That might be, but then you can't have both. You can't have that plus, right? It has to be one or the other.
Oh, I believe I understand what you're saying, and I do agree, actually. But the point is that you can't, the answer isn't to invalidate the liquidated damages provision. It's to make sure that the overlapping time period, there are no duplicative damages awarded.
Okay, thank you.
You're welcome.
Thank you all. It's been interesting. Thank you. Okay, the last case that we have on the calendar, my goodness, thank you for waiting, is English versus Avon Products. Let me first announce that Justice Moulton is recused from this case so that your bench will consist of the four of us. Okay? You can proceed.
Good afternoon, Your Honors. May it please the Court. This is Dave Rutkowski, counsel for defendant appellant Schulten, Inc. Now, this appeal is about whether New York can exercise specific jurisdiction over a non-resident corporate defendant with limited New York contacts that are unrelated to plaintiff's claims. Now, in this case, the claims against Schulten include Ms. English's alleged use of the Schulten's Desert Flower product from approximately the 1960s and 1970s.
Right, we're aware of the facts, so, you know, you could argue the jurisdictional issue.
I'll get straight.
Go right to it.
Thank you, Your Honor. I'll get straight to the point. So the lower court had erroneously found that New York could exercise specific jurisdiction, and they relied upon two main factors, both of which were not supported by the evidence in this case, and I will briefly address those. Now, first, the plaintiffs had argued that the presence of Schulten's international division in New York City, along with the related departments of art and design and marketing, is located in Rockefeller Center, was sufficient to establish this connection between plaintiff's claims and Schulten's New York contacts.
Sir, was it sufficient to establish New York for purposes of being a forum in the prior motion practice and in the prior appeal?
So the mere presence of that New York office is not sufficient. There must be an actual connection between.
I'm sorry, perhaps I wasn't clear. But you just described that it had a New York office for purposes of developing and marketing its products in New York. Wasn't that a factor that supported keeping the action in New York based on a prior order of the lower court that ultimately went to this court on forum non-convenient? Wasn't that a factor?
For the forum non-convenes?
Yes.
That was, we had filed that motion, and that was expressed in that motion, but from a jurisdictional standpoint, it's a separate standard where you have to have the actual connection between plaintiff's claims and Schulten's context specifically. The form.
So in other words, just to understand your argument, so forum nonconvenience, we weren't looking at jurisdiction. We were looking at convenience. And you had an office here, connection, right? And you're saying for the long-arm jurisdiction, though, there has to be a connection to the tort of Miss English. Is that it?
Yes.
So in other words, is it your claim that because she didn't purchase the talcum powder in New York, that New York doesn't have jurisdiction?
That is part of our claim, yes.
If she had, there would be, you would concede there was jurisdiction?
If she had purchased the
talcum powder, right, the product with the talcum powder.
Well, under the Supreme Court ruling in Bristol-Myers Squibb, that would be a factor that would be considered.
My understanding, I'm glad you raised that, counsel. My understanding in Bristol-Myers Squibb, and again, feel free to correct me, was the Supreme Court of the United States was taking the position that, I'm making up the number, so humor me, 300, 600 plaintiffs in a class action that joined about 80 some odd California residents were suing Bristol-Myers Squibb because Plavix caused them problems as a blood thinner. And what the Supreme Court was focusing on is that all those plaintiffs were not harmed in California, they were harmed in their respective places. True?
Correct.
Okay, so, but here we have a flight attendant, or she was a flight attendant, Miss English, who spent roughly several years using desert flower in New York, where there was a Schulten presence, of which desert flower talc, a component came from another New York company, Whittaker, Clark and Daniels. So against the matrix of those factors, that she used the product regularly, say hundreds of times in New York. So she was harmed by the product in New York, and Schulten had the presence in New York, albeit not as a principal place of business for general jurisdiction, but it had a presence with its international division office.
If I could just respond in that the...
You can. I'm just trying to see, would you disagree that that's different than Bristol-Myers Squibb?
I think it's slightly different in that the international division, there's no evidence that anything that the international division was handling had anything to do with the domestic development manufacture of the desert flower product. All of that ran out of the Clifton, New Jersey headquarters, and the evidence is in the record is clear on that, and I can point to one specific section. Now, plaintiff had tried to make that connection in that, out of that New York international division, that there was the art and design, the marketing department had applied to all Schulten products. And I believe they had on 733 of the record, plaintiff cited, unlike competitor, Schulten calls on its own artists, design specialists, which are able to create prototypes in any medium, design engineers, and skilled machinists. And they attempted to connect this, that they'd be using the art and design specialists from the New York office. However, if you look at the record, the paragraph before, that section of the Schulten promotional material is actually talking about the Clifton office, and that reads, from the start, Schulten upheld the highest quality of standards, aided in great measure by direct control over product and packaging alike.
So, counsel, let me just interrupt you. So your point, I think, is that what the international division did here in New York had nothing to do with the fact that the plaintiff flew in and used talcum here. Is that it?
Correct.
It wasn't a nexus between those two things. And you need that nexus under Bristol-Myers Squibb to have specific jurisdiction.
Correct. And the plaintiff, the record in this case, plaintiff only purchased the desert flower product in Texas, which is domestically. And
the international office didn't market in Texas.
correct. Well, there's no evidence in the record
one
that
way or
shows
the
that.
other.
And even if the court was to,
But is there evidence in the record that the international market did not market? Well, never mind, I'm going to withdraw
well,
that.
if I could
I think
just,
we understand, no, I think we understand your question. Let's hear from your adversary.
can I make one more point on the marketing?
I'm going to let you make one more point
I'll
on
be-
the marketing.
Thank you, Your Honor.
Yeah.
Even if you were to consider the marketing had a role in the desert flower product in Texas, it would actually still would not be connected to plaintiff's claims. The testimony is the plaintiff received the desert flower product as a gift. She did not purchase it herself at first, and she continued to use it because she enjoyed the smell. Now, there's nothing about marketing, there's nothing about art and design packaging in that would have caused her to...
Yeah, but, you know, that sort of ignores the reality of corporate America. You know, something's being marketed and she's buying it. You can't say that their marketing had nothing to do with her buying the product. I honestly, I think you're going too far with that. But okay, thank you. That's my personal opinion. I don't know how my colleagues feel.
Thank you.
Yeah.
Good afternoon. May it please the court, Jim Kramer from Simmons Hanley Conroy on behalf of the plaintiffs, Patricia Rosso and Linda English. I'd like to first address, Your Honors, a point that Justice Shulman just made, which I believe is the strongest point by which Justice Silvera held personal jurisdiction in this case, and that is under the long-arm statute 302A1, the transaction of business relevant to our claims is first and foremost the fact that Schulten was doing business with its primary talc supplier, Whitaker Clark & Daniels, in New York. Whitaker Clark & Daniels had their headquarters in New York, their sales offices were in New York, that's where they took the calls, took the orders, and of course...
I mean, Whitaker did.
Correct, with Schulten.
They have jurisdiction over Whitaker. There's no question about it. So how do you tie that up to Schulten?
Schulten was doing business and transacting business with New York-based Whitaker Clark & Daniels for the very talc that caused...
How do we know that they were doing it in New York?
Well, they admit that there was only one sales office, and that was within New York.
We don't know that they came to the sales office to do business with them. I mean, isn't that really a slender thread? What you're talking about really gives you jurisdiction clearly over Whitaker. They're in New York, right?
Well, under the Leachy case, Your Honor, I would argue that it is exactly that type of relationship which would show the connections one would need under the long-arm statute to establish jurisdiction. That's just one avenue of jurisdiction that Justice Silvera found, however. To go to the international headquarters, as was just discussed, Schulten had their entire cosmetic and toiletries division marketing department there, and quoting from page 745 of the record, which is a Schulten promotional material, Schulten admits that marketing is the most important function of the company.
But counsel, let me ask you, did the plaintiff testify that she was marketed to in New York?
No, but only, Your Honor, those questions weren't asked. As Your Honors are aware...
Did she put in an affidavit in support of the motion to deny dismissal on the basis of jurisdiction and say, oh no, I was marketed here in New York?
She did not, Your Honor.
So then how does the marketing connect to her tort?
To further read into what's actually in the evidence, and of course, all permissible inferences, all reasonable inferences go in our favor, Schulten admits that through its marketing, it took effective control of each of their brands.
But again, in Bristol-Myers Squibb, Prevacid was marketed across the country, right? That wasn't the linchpin is that activity connected to the tort. That's why I'm asking you, is there any evidence that that activity, New York activity, is connected, did the plaintiff connect it to her using the product?
Well, this is a failure to warn case, Your Honor, and all labeling, design of the product, design of the print on the product, all comes from this department in New York. And an important point, Your Honors, is this. I know there's been much focus on the Bristol-Myers decision. We would argue that the later decision, 2021, by the Supreme Court, in Ford v. Montana, is the controlling application of personal jurisdiction here. Justice Scarpelli, you look like you have a question.
I don't think that Ford Montana helps you out at all. I think it really doesn't help you out. I think it's even worse. But let me ask you, how do you deal with our New York gun case? Our New York Court of Appeals, our latest Court of Appeals is long-arm jurisdiction.
You know, I'll be frank, Your Honor, I'm not aware of the holding there. I'm not prepared to answer that.
Okay.
But under Ford v. Montana, what I can say is we're looking at almost an all-fours situation. The vehicles in question weren't purchased in either Montana or Minnesota. The accident occurred there, and it was established that by the contacts of Ford that reached into these states, including marketing, including the fact that they had offices there to service these cars, that was the connection that the court looked at, and they expressly said that any other reading of Bristol-Myers, where the plaintiffs that were dismissed had no relation to California. They didn't buy Plavix there. They weren't prescribed there. That is a misreading and misinterpretation of the law as it applied to the facts in Ford, which I think apply here. Very briefly, Your Honors, I want to cover a point not raised now, but raised in the papers as a primary reason to reject Justice Silvera's argument, which is the underlying order by Justice Mendez on the Johnson & Johnson issue. I think it's critical to point out that Johnson & Johnson did not have the connections to New York that Schulten had. Johnson & Johnson did not contract with Whitaker, Clark & Daniels for talc. They did not have any New York property. They did not have any New York presence. And it was those facts that led Justice Mendez to dismiss them on personal jurisdiction grounds. We do not have that here. And lastly, we do have the timeliness issue. We spell it out in our papers. I won't reiterate it here. Unless there are any other questions from the panel, I'll rest on our papers.
Oh,
Thank you.
Well, I should ask. Any questions? No. All right, we'll hear rebuttal.
Thank you. I will be brief.
Yeah.
On the issue about Whitaker, Clark, and Daniels, I will just add that there's nothing in the record that shows that Schulten signed any contracts in New York with Whitaker, Clark, and Daniels. There's nothing in the record that says they took delivery of any talc from Whitaker, Clark, and Daniels in New York. And the jurisdictional determination is on the connections for Schulten, not for the connections to Whitaker, Clark, and Daniels. And on one issue with the Cosmetic and Toiletries Division, I believe counsel had referenced that that was solely in New York. That's not true. There was also a Cosmetic and Toiletries Division in the Clifton, New Jersey office, which is the headquarters, the corporate epicenter, as you could say, for the Schulten manufacturing center as well. And lastly, going back to that one point on 732, the record does show that when Schulten was taking control of product marketing, advertisement, they were doing so from the Clifton office. It reads, not only are the products manufactured at Clifton, almost all of the company's domestic, which is the key word, requirements for gift boxes, plastic bottles, plastic components are produced and assembled there.
Counsel, can I ask you, is there any evidence in the record that the decision whether or not to warn was made in New York? So your adversary said, look, this is a failure to warn case, and that's the connection. Is there any evidence on that issue, whether or not the marketing department in New York made a decision to not warn about potential asbestos in talc or whatever?
I am not aware of any evidence.
So there's no evidence either way whether that was, that decision, that failure to warn was made here in New York?
Correct.
Okay.
Was the marketing department in charge of labeling? Was that part of their responsibilities? I'm not talking about duty to warn. I'm talking about labeling for marketing purposes. What the bottles look like, what the bottles should say.
Well, for the purposes of the desert flower product that the plaintiff had used, that was a domestic product that would have been handled solely from the Clifton, New Jersey office.
Okay, thank you.
Thank you.